Good afternoon. I'd like to call the Rules and City Government Committee meeting to order. I do apologize. We were taking care of some business and we're waiting for one of our colleagues who's running a little late, but we're going to start without him and hopefully he'll join us very soon. For the record, Alderman Arnett and I are present. I'd entertain a motion to approve the agenda.
Madam Chair, I move to approve the agenda, although I have a question. Because we have not made a final determination on O-2024, is it appropriate to have on the agenda R-4324, which is the fees that are associated with O-2024? I mean, yes, we can do it simultaneously, but it struck me till we dispose of recommendations on O-2024, and actually till the council votes for it, is the fee appropriate at this point?
I'm looking for, you said O-20 you think should not be on the agenda.
No, I think O-20 is on the agenda, but
Right.
it is, we haven't made a final deliberation from this committee, but it also has not gone to the council for a vote. And the fees in R-4324 are relevant to passage of 2024.
But we did approve R-23, did we not?
R-43.
R-43. Oh, we
don't
did
think
not.
so.
I thought you
Yeah.
said R-23.
No.
So that's my confusion.
Yeah.
So are you suggesting that we take up R-43 prior to O?
No, I'm suggesting it's not appropriate to take up R-43 until we've agreed to O-2024. Because there are changes in O-2024 that the resolution has to do with the late fee amount. And until we agree on late fees and the amounts, doesn't seem to me that, I think we're doing two things simultaneously rather than one being passed and then the other following.
I understand what you're saying. You know, traditionally, we have said that the ordinance and the resolution should travel together.
Okay?
But if that doesn't work in this situation, then I'm good with whatever will work.
Well, I've made a motion to approve the agenda.
Right.
And they're both on. I just was raising the question about that.
Well, we can, I don't recall how I thought we took up O-20 in full council. We did not.
We did, but we deferred it back to the Board of Supervisors of Elections. We approved the other three ordinances.
Right.
We did not recommend an approval on this one.
So it is before our body before it goes back to the full council, along with the fee schedule.
Correct.
So it is our responsibility, our business, to take up O-20, I'm thinking.
Yes, correct.
So, and it's on the agenda,
Yes.
as is R-43 after O-20. So,
All right.
and you're looking at how much time we have on the
No,
clock.
I'm actually getting rid of a text message.
So let's have, if there's further discussion about this, let's do it when it comes up on the agenda.
Okay.
I'll second the motion to approve the agenda as written. All in favor, please say aye.
Aye.
I'll entertain a motion to approve the minutes from the October 4th meeting.
So move.
Second, all in favor, please say aye.
Aye.
Aye, thank you. We have two appointments before us this afternoon. Mr. Patrick Hogan being appointed to the Ethics Commission. Mr. Hogan, have a seat. Would you press the green button where it says, is it already on?
It's good.
Good.
Would you give us your name and
Sure.
address, please?
Name is Patrick Hogan. I live at 5 Brook Avenue in Murray Hill in Ward 1.
Thank you. So tell us about your interest in the Ethics Commission.
Sure. Madam Chairman, Alderman Arnett, I go by PJ Hogan.
I noticed you hesitated on your first name.
I know, I'm not used to saying Patrick. I do know my first name, I just don't go by it. You have my question and answer sheet and my resume, I was asked if I would like to serve on the City Ethics Commission. I'd be proud and honored to serve our city in that fashion. I think my lengthy experience in and out of government over 30 years gives me the experience, the background, the knowledge to serve on the Ethics Commission, and I'd like to help in any way I can.
Why the Ethics Commission of all of our opportunities? And you couch that to all of our opportunities.
That was the one I was asked if I would be interested in. No.
Okay.
I didn't seek it out. It was brought up to me.
Well, great. Other questions? Alderman Schellemeyer has joined us. This is Mr. P.J. Hogan, who is up for appointment to the Ethics Commission. So take your time.
Yes, Madam Chair. So I have actually worked with Mr. Hogan in the past during my time in the General Assembly as a staffer. I am familiar with his work in the past, and I can speak to his character, his work ethic, and I think he'd be a fantastic addition here.
Okay, well,
Thank you.
timely, wasn't that? Alderman Arnett?
I also agree the background is tremendous, and we'll take you on any committee, but we're happy to fill this. And I did like your statement. I think that ethics and transparency is one of the cornerstones for good governance. So I'm very pleased to see that on your part. I did have one question. Being a member of the Alumni Association for the University of Maryland, your degree is from Indiana of Pennsylvania. Was this a recognition from the Alumni Association? You're not on the Alumni Association itself, right?
No, I'm not sure which.
In your
my
award?
college degree is from Indiana University of Pennsylvania. I grew up in Pittsburgh, Pennsylvania.
Right.
Went to IU, Indiana University of Pennsylvania. I moved to Maryland in 1990. Worked for former member of Congress, Connie Morella, from 90 to 94. I ran and was elected to the state senate in 1994, representing District 39, which is the top half of Montgomery County. Served in the Senate from 94 to 2007, when I was asked by the Chancellor of the University System of Maryland, maybe this is what you're referencing, to come and be his Vice Chancellor. So I was Vice Chancellor of the University System of Maryland for 8 years, from 2007 to 2015. I was then asked to open up a government relations firm here in Annapolis, Cornerstone Government Affairs, which is at the bottom of Francis Street. I ran that office from 2015 to 2023. I retired in the end of 2023. The only thing that's not on here, I then got my master's boat captain's license, and I now work for Watermark, driving the Miss Anne and the water taxis. So I'm retired, but working a little part-time, which is another reason I wanted to. I've lived in the city for 9 years. Obviously, I started visiting the city, living here 3 months a year from 94 on, but I love the city of Annapolis and wanted to serve in any way I can.
I saw in the beginning of your resume, fellow TERP, Alumni Association. When did he graduate? And then I see, wait a minute, he didn't graduate from Maryland. So that was just a little disconnect.
Oh, that was an award from the
Right.
for my work in higher education.
Yeah, so I think I'm prepared to make a motion that we recommend favorably.
Well, actually, Madam Chair, I have one question after learning of a Pittsburgh connection.
Uh-oh.
Do you still believe that French fries belong on sandwiches?
I have had a Permane Brothers sandwich with the French fries. It's not my favorite, no, I prefer them on the side.
I am going to second Alderman Arnett's favorable recommendation.
In spite of that, right?
No, actually because of it. They get soggy on top.
Yeah.
Well, thank you, gentlemen. I feel like I have to say that I recognized your name from your days in the legislature when I was president of the Teachers Association. So thank you again for volunteering. So there's a motion on the floor to give a favorable recommendation to Mr. Patrick P.J. Hogan for the Ethics Commission. All in favor, please say aye.
Aye.
Aye. Thank you. Your name will go before the council at the next meeting. You're not required to be there. You won't have an opportunity to speak or anything. So the full council will make the final decision. And thank you for offering your service.
Thank you. Thank you all.
Okay, our next appointment is Mr. Everett Bellamy, appointment to the Planning Commission. Mr. Bellamy, join us.
Good afternoon. It's a pleasure to be here.
Oh, our pleasure. Could you give us your name and your address, please?
My name is Everett Bellamy, and I live at 1109 August Drive, Annapolis, Maryland.
Well, thank you. So you're being recommended for the Planning Commission.
That's correct.
So would you tell us a little bit about your interest and why your background would prepare you to be on the Planning Commission?
For certain. I've spent most of my career in higher education, first working with undergraduate students, and then once I graduated from law school, I became a dean at Georgetown University Law Center, a position in which I served for 30 years. I also was an adjunct professor. I created and taught a course on small business law and entrepreneurship for 28 years. It was one of the first courses of its kind taught at a law school in the country. I have advised startup companies and worked with entrepreneurs for over 30 years. And I moved to, previously I lived in Silver Spring. I'm originally from Chicago, Illinois, and I moved to Maryland to take the job at Georgetown in 1980. And I lived in Silver Spring up until December of 2018, after I retired from Georgetown. And I moved to Annapolis. So I've been here since December of 2018, and I love the city. It's a beautiful city, and I'm glad I made the transition. Now, I moved here because as I said, I had retired. Little did I know that Georgetown would invite me back on an interim basis to work in diversity, equity, and inclusion for a year and a half, which I did up until that contract ended in December of 2022. So I didn't know I would be commuting from Annapolis to DC, but it was fine. I had flexible work hours, and Highway 50 wasn't that bad by the time I went to work every day. And so in light of my retirement, I've always wanted to stay engaged. I still help students who are interested in going to law school. I still work with some startup companies. But I wanted to get involved in my community here in Annapolis, since this is my new home. And so I reached out and applied online to the city to see if I could serve on a board or a commission and offer my expertise in whatever way I can be of help. And the mayor assistant contacted me and set up a coffee meeting with the mayor, and I chatted with him about my background and interest. And he thought that the Planning Commission would be a good place for me. I care deeply not only about the city, but about also development, green space, the environment, all the things that we're looking at as we look at the effect of climate change on our environments and things that we should be doing whenever we're doing construction or interrupting green spaces, cutting down trees, whatever. So I thought that would maybe be a good fit, just based on my deep interest in those areas. And so that's what the mayor and I decided we would go for.
Well, thank you. Questions for Mr. Bellamy? Alderman Chennemeyer?
Yes, thank you, Madam Chair. So I appreciate your background in entrepreneurship and business law. We have a lot of overlaying aspects of our code that I think can discourage entrepreneurship here in the city. So I appreciate someone going into the Planning Commission that may understand some of those struggles and difficulties. Something I always like to ask, though, of anyone who wants to come forward to our Planning Commission, have you ever read Strong Towns?
Have you ever read what?
The book Strong Towns.
No, I haven't.
If I lend you a copy, would you be willing to read it? It's a pretty easy read.
No, don't read it, don't read it.
Don't read it. Yes, I would be interested in reading it.
All right. I'll talk with you. I'll give you a call after the meeting sometime.
Wonderful, thank you.
Okay, Alderman Arnett?
Yes, thank you, Madam Chair. So first of all, I think you have a very strong background, and I think you're going to bring a perspective to the Planning Commission that we need to have. Just a byplay on Strong Towns, I happen to think Annapolis is the example that Strong Town tries to make that what the rest of the country, instead of urban sprawl, should become, like Annapolis. So you can see there's some divergence of opinion there, but the Planning Commission has two big principal roles. One is they're in charge with adjudicating large plan development. The other one, which may give you less pleasure, is you also get to opine on our legislation. So it'll be an interesting thing for you to do, but I think it's one of the really important, all of our boards and commissions are important, but Planning Commission has a very vital role. We just got through with a comprehensive planning process, which is a new sort of pathway for the city to proceed to develop. And we're talking about some changes in the zoning map and changes in the kinds of zoning categories we have. So it's a particularly interesting and exciting time to join the Planning Commission. So,
Sounds great.
yeah.
Well, you haven't shied away yet, so that's all good. Alderman Arnett mentioned the planning document that it's required every 10 years. We're a little bit late. But after your appointment, that would probably be a really good document to kind of digest, to find out exactly what we perceive at the council as moving forward as far as land use for the most part in our city. I mean, it includes a lot of other things like transportation and housing and all of that, but it's primarily a land use document. So just additional reading in your spare time. So.
Okay.
It's only close to 1,000 pages long.
Is that,
Was that the final draft? Is 1,000 pages?
With the action plan and the
And the
appendices.
appendix.
There's a lot of pictures.
Yeah, right.
So, gentlemen, I'll entertain a motion.
So moved.
Second.
So further discussion, hearing none, all in favor of making a favorable recommendation of Mr. Everett Bellamy to the Planning Commission, please say aye.
Aye.
Aye. Our recommendation will go to the full council at the next meeting. You're not required to be there. You won't get to talk or anything. You could wait, but that's the extent of it. And the full council will make the decision, and you'll be notified, so.
okay, will I be notified as when that meeting is?
Yes.
Okay.
Ms. Raftovich, who handles their boards and commissions, will probably be the one to reach out to you and give you your, I shouldn't say your start date. We'll let you know.
Wonderful. Okay, well, thank you so much for your time. I
And
appreciate
thank you for joining us today. Okay. Next item, Office of Community Service update. Ms. Buckland, I'm a little disturbed. We can never get the director of this department to one of our meetings. What's it going to take?
I guarantee she will be here next time.
Thank you.
I do want to give you an update, though, on what's been happening there. As you know, the office oversees the 3 grant programs. Of those, for the community grants, there are a total of 52. 4 of them are still in process. For 3 of them, we're still actually waiting on forms back for vendor registration. Had multiple outreach to them, may be reaching out for some help to get a couple of those across the finish line. And we have one where we're actually still waiting on a signature on a contract. Everybody else is done. We have resent copies of all purchase orders, and those payments are in and have been going through. For the Adopt a Community grants, all of those initial payments are done. There are 2 contracts. Thank you I had reached out about one of them. There is a second one that we finally just recently got back, so that one is in process to create a purchase order, and then we'll have the payment out. But we just got that one back, so that one is still in process. And then there were 5 organizations that were identified for the Child and Family Success Grants. That was, council had allocated $50,000, so each of them will be getting 10. And those are just now, that decision was made relatively recently. Those are in process for getting signed and then executed. So all of those are in process. The rental assistance program, the initial funding for that, we are at the point where we have closed applications. For the last couple of years, certainly since I've been here, we know that there are things that come up over the course of the year, and so we don't like to spend every single dime immediately. We do leave a very, very small cushion, not a lot, but enough so that if we have truly an emergency situation, we're able to provide some assistance outside of this initial period. But we do try to spend the bulk of it as applications come in. But we have reached that point. So the application portal is closed. And at this point, if you end up finding out about particular situations, please outreach and we'll see. In the meantime, then people who have a need, Erin Lee, our social worker, is working with them to make sure that we connect folks with other kinds of resource and do a little bit more intensive case management to try to still provide help and support, even if we're not able to write a check. So we're trying not to just leave people out in the cold. We're trying to get them connected to other kinds of things. And then we, of course, have this is a kind of a busy time of year. There are all kinds of community events going on. The office, we had the citation recently for Black Mental Health Matters 2 that council gave. So OCS did a partnership with them to do some joint work together, and they've been trying to outreach to a number of different organizations to make sure that folks know that resources are available and how to get hold of the office and stuff like that. They do have a resource booklet. Have you guys received a copy of that? Let me make a note to make sure you have a copy of that. Just not only for your own edification, but also then, making sure that that's sort of generally available. So I'll make sure when a copy gets in your hands.
I think that would be very helpful. I was going to ask you not to put more work on your plate, but if you could give us a little written summary of your report.
Yep.
So that we can see from month to month the progress that we're making. We we approve funding for a number of sources, and I'm not sure whether any of us know all of the opportunities for assistance that there is in the city. So if that resource book will share that information with us, it'll be very helpful, and we can share with the community.
Yep, absolutely.
So, I didn't mean to cut you off, though.
No. Those are the highlights for this last month.
Well, great. Thank you very much for sharing that information. And I look forward to, like I said, being able to follow up with those. And the person I contacted promised he'd get it in on Monday. I missed the connection, but I hope he made it independently.
I will check.
Yes. If not, I will follow up again.
Thank you.
And if there's any others, especially if they're in our wards, that we can help
Yep.
facilitate. I don't understand how people don't want to come for money that's already been approved, but that's a whole nother discussion. Thank you, Ms. Buckland, for
welcome.
sharing that information. Okay, going on to legislation, 02623, Forest Conservation Plan Appeals. Alderman Savage is not here. We have one amendment. Did Alderman Savage withdraw this amendment?
I don't believe so.
We have the Planning Commission's findings. Alderman Arnett, can you share your?
So I will ask to be a co-sponsor of this legislation. Therefore, I do support it. And it, in its simplest form, it is unifying where the appeals to forest stand delineation go, and that is to the Zoning Board of Appeals. And that makes sense to me. However, and while the Planning Commission voted 4-0 to support this legislation, in their report, and I see we have the Planning and Zoning Director here, and maybe we can ask Mr. Jakubiec to come forward. They noted several things in their report that I found interesting, and I'm looking on the, I believe
So
it's
you're looking on the Planning Commission's
Planning
report
Commission,
or the staff
Planning
report?
Commission, the Planning Commission report on page 2. They say that they recommend that the amendment itself should be amended to reflect recommendations, and I think that's what Alderman Savage's amendment speaks to. But then they raise some very interesting questions about the advisability of allowing appeals by an applicant or aggrieved member of the community to the forest stand delineation at all. And they point out that it is something that is developed on the part of experts. And further down towards the middle of the page, they talk about the appeals being made by significant groups. And then in the last paragraph, local environmental groups. So it feels like on one hand, the Planning Commission is recommending favorably. On the other hand, and I think in a way, Alderwoman Finlayson, they're speaking to Providence Point.
Well,
And so I think that I'd really like to hear the planning director's view of the Planning Commission's recommendation to us, because it feels that they're really saying two different things.
thank you. And I've signaled Mr. Jakubiec has joined us. He's our Director of Planning and Zoning. So tell us how you really feel about this piece of legislation. We're looking at the Planning Commission's recommendations right now.
Thank you. I feel the administrative, an appeal should not be used to dispute an expert's delineation report. A delineation report is not a policy, it's not a development, it's a description of what exists now. And it's done by an expert, and the Board of Appeals would be substituting its judgment for the judgment of an expert. It's not a plan, it's not a decision, it's what the expert finds in the field to be the case. So I think the Planning Commission is correct in its evaluation of that topic.
So it appears that we're talking about standing,
Well,
and who
and,
has
so-
standing and for what.
Exactly.
And
So if they're not appealing the expert opinion, what is it that they are appealing?
and why? Should that be an allowable response?
You might not have these pieces of paper in front of you,
I
but
don't have the staff, the Planning Commission's,
I'll bring you down my copy. And it's very helpfully highlighted in magic markers.
oh, good. Oh, jeez.
Ross, where is the definition of standing? And I'm looking in the original language, the original legislation.
I can't find standing in
Yeah, I think it's probably elsewhere in the code, but I think the broader,
Could we ask Ms. Reuter to find where standing is defined in the city code?
It is not defined in the city code. It's set by court rulings.
right. So
So
standing,
that should be stated somewhere in our documents, shouldn't it? Mr. Jakubiec, how do you,
This is an important concept and a difficult one. And case law in Maryland establishes standing generally with respect to these zoning decisions. And typically, it's someone who's aggrieved by and potentially impacted by a decision. And usually that's a dimensional standard within 200 feet is a standard that seems to be the rule that the courts recognize. But we don't have in Annapolis a statement of what standing is in our code. And candidly, I don't know if that should be remedied or if that's just fine. That's a legal analysis. I just don't have an answer for.
so,
well, I guess, if I might, because Providence Point is in my ward,
Yes.
and the Planning Commission approved that project. And another organization is now appealing it. And someone, and you guys, the planning department, put it through all over the last 15 years, literally, because we've been here the whole time. It's probably been
we
more
were
than-
teenagers when it was
Really, we
introduced.
were young back then.
I'm actually going to state I literally was a teenager.
Were you born? No, I'm
Bagger.
I was, but I was 17.
Really? So all of a sudden, standing seems to have changed in order to allow an organization to appeal it. So what ruling are what rule are we following to allow that, which clearly goes beyond the state standard for standing? Am I wrong?
I don't know that this is changing standing. I didn't think that was part of this ordinance.
Well, no, this ordinance doesn't change standing.
No, so there is another ordinance that's in draft that I've been working with the Office of Law on, where this term standing has become quite a bit of debate, and Mr. Kubiak is correct from what I draw. Standing is a state word. It's used very specifically in a technical way, and it has people who have to do with people who have a vested interest in the final decision, which would be the final decision of the Planning Commission in the case of a planned development. What the Planning Commission is raising, though, I think in their remarks, is this is an internal process that is one that is formed with the opinion of experts, and they're saying, should that really be something that anyone with a financial interest or nearby neighbor could appeal, and how could they appeal it if it's expert and accepted as expert testimony? So, and I know Alderman Savage would be furious with me for bringing this up. He had a conflicting engagement. He would have been here for several pieces of legislation. But I do think, I mean, we have a planning commission for a reason, and part of that is to sort of step back and look at what we're doing and say, does this make sense? And I think the points that they're making on page 2 of their report are really something that we ought to be thinking about. It would be like me appealing the level of a sewer line that my next door neighbor is putting in. Does it have the proper gravitational flow? I'm not an expert in that. So it's almost like getting into these internal processes. And I'm more than willing, the reason I'm bringing this up, and as someone who's willing to be a sponsor of this, because I think there is a loophole and we need to close it, but I also think we need to get our legislation right. And the Planning Commission, I think, has raised 2 or 3 philosophical questions about whether at what stage or what point should things be appealed, and are they just really appealable by anybody? Standing in the state, it seems to me, is part of the research, and Cynthia, you can correct me, but had to do with experts challenging experts, not interested parties challenging experts. And so, yeah, you might want to speak to this, because I probably got it wrong. But anyway, I just think we ought to pay attention to what the Planning Commission was raising there, because that's why we have them.
Ms. Reuter?
So there's a difference between standing before the city council and then, or judicial boards, and standing in the courts. The courts basically, anybody can file, but the courts decide who has standing.
Right.
And they base their, generally in Maryland, I was just researching this yesterday. Generally in Maryland, they limit it to people who have a direct vested interest in this situation.
Is that a financial interest, or
It could be
what
either.
does that mean?
It could be financial, or you're very close to
You're an
the
adjoining.
issue. Look, physically, like your house is next door to, the area that's being
And that's the
considered.
200-foot barrier, right?
Right. But the standing in the courts is constantly shifting, depending upon the latest ruling. And so that's why it's not in the code anywhere, because it's a shifting standard. And I'll have more in my report when I'm done on what kind of, how the city can handle it in the code.
So, Madam Chair, as I said, I think Alderman Savage would be frustrated with me, which wouldn't be the first time. But it does seem to me that if there's going to be an appeal, the right place for an appeal would be to the Zoning Board of Appeals. And I like that consolidation. But I do think the Planning Commission raises a legitimate question about at what point in the process is something appealable. They're saying experts have opined on the forest stand delineation. And unless you have other experts that are bringing up issues to say they got it wrong, is that really an appealable point? And in the process, if I'm understanding, I don't know, Mr. Jakubiec, if you were at the Planning Commission when this was discussed, but I think this really is a matter of when does something become more generally appealable out of the state standing versus in the approval process where we're relying on experts' opinions. Aren't you so glad that I brought this up?
Well, what this also tells me is that, because I have a piece of pending legislation also,
Right.
and I think maybe it would be beneficial if we talked and could work together on this. I know you think that there's different sides of this argument, and there are, but there's no reason, I believe, that we can't come together and come up with one solution. I strongly believe that our planning department makes wise decisions based upon the code that we provided them and the processes and so forth. And likewise with the Planning Commission, they have a definite role. And so I think our issue should be what happens when people choose to ignore those two strong bodies that represent the city. And I don't know whether that addresses what you're...
Well, as I said, my reason for complicating today's process is because I think the Planning Commission, on one hand, approves, on the other hand, is raising important procedural questions that we shouldn't just ignore.
So are we on to the amendment? Have we addressed the Planning Commission's concerns? Yes or no? Alderman Chandler.
Thank you, Madam Chair. So I think where we're, I will fully admit I was a little trying to find where the Planning Commission's concerns were coming from in the legislation itself, and I believe I found it in the amendment, and it's on page 1 of the amendment, section 3 of page 1.
The Savage Amendment?
Yes, ma'am. So page 1, it's 3. So, yeah, page 1 of 7. The
1 of
Savage
7.
Amendment. Yeah.
Okay.
So down on to 10. Yep. So the approval of a forest delineation by the department may be appealed by a resident of Annapolis or environmental group located within an Annapolis Creek watershed. And an appeal of a forest stand delineation that is part of the project will go to the Planning Commission for approval. So the approval may be, so I think it's that section 10, part A, that really widens out who can approve these who can widen out these appeal of the decisions. I think that's where the Planning Commission's concerns are coming from. Director Kupiak, is that your interpretation of their concerns?
Yes, it is, and I'm glad you read that. I benefited from that recitation too, but that is my concern.
Yeah. I think that really widens out who can appeal this stuff, and we have a code that already slows and gums up a lot of things. And by expanding that out further, I think we end up with a lot further problems with some of the other crises facing our city, like housing issues. And I can see why that part has made our Planning Commission uncomfortable.
So it sounds like you're saying two different things, but I don't think you are.
I understand the Planning Commission's discomfort with that part of the widening of who may appeal a decision. So I like the legislation as a whole. I have a problem with that ish part of Amendment 1.
Okay.
And I would like to see that part scratched out, but if my colleagues disagree, I understand.
No,
That's legislation.
Alderman Arnett?
So actually, I do agree with you. I would rather postpone and have Alderman Savage come back to speak to this, but that's why I appealed to you, Alderwoman, because we're seeing this cropping up. And you're right, Alderman Chandlemeyer, we are expanding who can jump into the game after years and years of deliberation, expert finding, expenditures of money, and so forth. On the other hand, some of these people that are cropping up are some of my best friends. And they're part of the environmental movement. So I'm torn, and I was torn about actually pointing this out. We could have just cruised through, accepted the amendment, but I don't think that's being fair to the Planning Commission who gave this some thought. And I do think it's an important policy question for us, and in their recommendations, they turn it back to us and say, this is a real policy question. And that's why I'm happy to have the director here. Maybe you can give us some guidance. Should we give this further consideration?
My guidance would be yes, and postpone it until you have a time for the alderman to be here to discuss it, but also for us to be prepared too, and perhaps even to have the chairman of the Planning Commission to discuss this. And lastly, to think about it in the context of other standing issues and appeals issues that are embedded in at least 2 other ordinances that are moving through the drafting process. Appeals are a fundamental issue. In fact, the developers that HACA is looking at for the redevelopment of the CNI project, a public purpose would be achieved with the redevelopment of that, are seriously concerned about the appeals that have been alleged against the Eastport project. Not the appeals per se, but the process for appeals and the delay, because any investor would be concerned about how long a project takes. And we have evidence of more than one project in Annapolis that's tied up in appeals. So
How long has that project been going on, if you don't mind?
at least a decade, but
It's
5 years?
Yeah, easily 5 years.
Easily.
let's see.
So
It's been appealed and reappealed, and it's been denied twice. Are we finally done? Are we going to permit them to go forward?
It's my understanding that well, we're not holding them up.
No, I know that.
Yeah, it's my understanding that the appeals are finished. The substantive appeals are finished, but that is not going to necessarily prevent the appellant from making other appeals. So it's going to be up to the courts to decide when enough is enough.
So I'm going to agree with delaying action because I do hate up or downing someone's legislation, especially or altering it if they're not here to accept it or defend it. But I do want to say a big part of my concern on this is our appeals process has caused several projects in the city to be going on. Some of them are now finally completed. Some of them, the builders have backed out relatively recently, since I was a literal teenager. I'm 34 now. I'm starting to get gray hairs on the temples. But since I just got my license, or in other cases, since before I had my license, that's not functional. And that needs to have a hard look at that.
Yeah.
So we should really take a look at that. So, Madam Chair, would it be appropriate for me to make a motion to postpone action?
I would accept that, and actually, it's already been moved. I believe you can second it.
I will second the motion then.
But I will have to add my piece of discussion to this, being the senior member, only by 10 minutes of the council. I've seen more than enough workforce housing projects that the developers just threw up their hands and said, we can't deal with the city. At least 4, probably 5 on Forest Drive between the American Legion and the Rocky Gorge property, just on that side of the street. And I know there's been probably 1 or 2 on the other side of Forest Drive. So we have lost a lot of opportunities for housing because of the process, and particularly because of the appeals. So, and it's unfortunate, you know about my legislation, I didn't know about yours, thank you. But we should fix this, because if we're really sincere about bringing workforce housing into the city and making our city more friendly to everyone, we need to fix this. So I totally support postponing it, because we should get it right. So thank you, Mr. Jakubiec, for
Your
sharing.
surprise visit.
I actually attended this meeting for some other agenda items. So, but apparently quite a few interface with planning and zoning, so I'll be here for a while.
Yeah.
So-
I wanted to just note, I'm not in favor of eliminating people's right to appeal. I think that should always be protected, but I do think it should be in the right place in the process. And I also don't like nuisance appealing that are holding up some perfectly good projects just because people can do it. So we have to find a balance, but we also have to find the right place for this to come into question, so.
And we have to trust our planning department as well as our planning commission to use their professional knowledge and advice to guide us. That's my,
I'm not
final
going that
premise.
far, but
I know you won't, but I can. So thank you. And so the motion is that we postpone action on 026 until the next meeting. Is that what I'm hearing?
yes.
And it's been seconded. All in favor, please say aye.
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 Didn't want to put you on the
Okay.
spot.
Going on to 03323, expiration of special exceptions to city zoning requirements.
Yes.
So this is yours, right, Alderman Chenoweth?
Yes, Alderman Arnett. The goal of this legislation is to, it's twofold. It's to, one, extend our special exception process from 1 year to 2 years, and then allow 2 one-year extensions on the process. The goal of this is to allow greater flexibility for our special exceptions. The construction industry, especially recently, has had a lot of issues with material shortages, labor shortages, and the goal is just sort of give a little more flexibility. Part of this was inspired by the recent daycare coming up in my ward, the Primrose Project, hit its limit, and now they can't get its use and occupancy permit. So
Is that because they went beyond the 6-month?
They hit their extension limit.
Okay. Alderman Arnett?
Yes, thank you. So, Madam Chair, I'm supportive of this legislation, but I did want to once again note the recommendation from the Planning Commission. I think part of this was due to the so-called zombie legislation that had to do with Rocky Gorge, where it had been denied, and then all of a sudden it came back up. So the Planning Commission is recommending an amendment which the use has ceased for more than 2 years and would apply for a second extension. And I'm wondering, Alderman Chandlemeyer, what your sense is, your attitude towards that recommendation on part of the Planning Commission?
I believe Amendment 1 addresses that and has a expiration of the special exception process. If the Planning and Zoning Director will come back up if he wants to discuss that, if he thinks that's sufficient. If he thinks that is not sufficient, I am more than happy to add that on. Because, yeah, this does, I believe Amendment 1 does allow that ending of the extensions after that 4 years. I did work with him pretty extensively to try and block that out their point. And there's also a point where if we deem, the Board of Appeals deems the neighborhood character sufficiently changed, it can end those special exception extensions.
Am I reading this correctly? The second bullet deals with from 6 months to 3 years. I thought yours was 2 years.
Sorry, this meeting was back in like the end of July.
Yeah, sorry, I know.
Prior,
You're talking about number 3 under B in the amendment?
I think this is Planning Commission.
I'm at the Planning Commission's findings, I think. On page 1.
Or after 3 years.
But I'm not seeing it further back. I'm sure it is. I just can't enlarge it enough.
It's on page 4 of the Planning Commission at the very end. And I'm not sure, Alderman Chandlemeyer, do you believe that your amendment B number 3 speaks to that?
Alderman Arnett, I do apologize. I was reading the Planning Commission's findings and I was not listening to you.
Oh, right. Well, I'm just.
Can you repeat the question?
I think Alderwoman Finlayson is pointing out we have 2, 3, and 4 years floating around here. You pointed to your amendment, which under B3, in any case where a special exception has not been established within 4 years after the date of granting the special exception, modification of special exception or extension of the special exception prior to the adoption, the special exception shall expire. So that's speaking specifically to special exceptions, and the Planning Commission on their recommendation said
3 years.
2 years actually apply for a second extension, which would make it effectively 3 years, I believe. It's hard to follow the bouncing ball in terms of.
I want one of those screens. You can have one here, and one here.
I know.
You can read all the documents at the same time. I'm sure you can do it, but I'm just not
So I think
capable.
the planning director has some comments.
Mr. Kubiak?
Sure. So first, what's on the table is the Amendment 1, which effectively is a major rewrite of the original legislation. I just want everyone to know that we're talking about Amendment 1, not the original draft. And the Planning Commission's comment dealt with Section D2. And D2 is under the heading Cessation of Established Special Exception Use. It's not about forming a special exception. It's about what happens if a special exception use ceases to exist for a period of time. Okay, and if you go down to D1 and 2, you'll see that the language is pretty much the same as the existing language. And if you go to D2, it says the Board of Appeals, upon showing of good cause, may grant up to 2 successive extensions of a special exception which has ceased. So you might imagine a restaurant is a permitted special exception. It is a closed shop during a period of transitioning to another owner.
There are 2 Ds, I got it, but you don't first.
The Board of Appeals can grant extensions of that special exception use if after a year the use has ceased. What the Planning Commission is saying is that a use that has ceased for more than 2 years may apply for an extension as well, subject to the standards. I think this probably inartfully drafted, but essentially allows for a second round of extension requests.
So the amendment complies with the sense of the Planning Commission recommendation.
Right, yeah.
That's what I needed to hear.
Okay, I'm concerned, because what I'm reading, and I don't have any substantial issues with the language or the change or the accommodation. I'm looking at this change to the first reader version. What am I reading here? We should have one version. We should have the original and then the amended version. Alderman Schnellmeyer, on page 2 of 4, this is all new language that we're replacing. We're replacing this with, and there's no numbers attached, so I'm just not clear on where this all goes. Ms. Reuter, can you help us out with figuring this out? Amendment 1, Mr. Alderman Schnellmeyer's amendment, beginning on page 2, it says changes to the first reader version. So where are we dropping that into? I mean, I don't know where it goes. In the original legislation.
It's replacing the red in the original legislation with this new blue.
All of the red, and it's two groups of red wording. So is it all under A?
The amendment,
21-26-070? Is that where it all goes?
I believe the amendment deals with only one portion of the bill. It's a big portion, but it's only a portion.
So where?
And it strikes that entire portion and replaces it.
So if you go down to changes to the first reader version, which is on page 2.
Okay, so this goes in here.
Yes, ma'am.
And from here on out, and I'm on the original legislation on page 1, A under 21-26-070, all of this is being replaced to the end or just to letter C?
So
Just to letter C.
yep, go to A, and then goes all the way down to letter C.
Okay. So could that be indicated on the amendment so we know where to drop that language in, and the lines and page numbers would be helpful? So C1A and 2A and new D will follow the new the amendment.
I
Am I the only one confused by this?
No, it's a lot of stuff changed. So part of the rationale there was like kind of a lot of changing was how it was originally written without some of these additional language. It could have just done a lot of perpetual extensions that the planning and zoning director was uncomfortable with. So this was kind of the goal to put more of these sunset provisions in. But
And I don't have any issues with the substance. I just want to make sure we know where everything goes. If we're expected to approve it today, it needs to be clear, because it's going to our council, colleagues next, and they need to understand where this goes.
That's what the, at the bottom of the amendment, that's what the changes to the first reader portion is. So if you'll scroll down on your, back to the left, yep, see changes to the first reader version, and that's where it will show it in the color-coded format, where the red was the original drafted bill, and the blue is the change to the amended change to the drafted bill.
So is it possible that we could put in the code section, which on your original 212607 as a heading, so that we'll know that's the section this goes into? Because it goes right here, right?
Yes, ma'am. Ms. Reuter, could we have that done for our next?
Yeah, so another way, unless they're going to give us, and Alderman Savage has this, a
Side by
desktop
side.
with split
He
screens.
does too. It's just us, because we don't know
Yeah, I
any
know,
better.
because we have this 1940s technology.
Well, we're from that period.
If
Because
we
you guys use Granicus and not Legistar.
If we
You gotta
could-
use Legistar.
if we could get like a version, if the amendment was accepted, how would everything look, which you kind of can piece together here, but it is hard to follow the bouncing ball because it's multicolor. I can't wait for green to start showing up.
We didn't used to have red and blue, but all of a sudden now it's this, okay, that's my issue, so. All right, I am comfortable with the language as long as you're comfortable with addressing the planning commissions.
Yes. The amendment addressed the planning commission, and the amendment was drafted to address the concerns of our planning director for making sure that this had a respectable sunset and could update with the changes in the community and having like a Board of Appeals stopgap. And I thought it was a pretty good way to adapt and adjust.
Are you,
Mr. Kubiak?
I agree with the Alderman. I also want to share one thing about the Planning Commission's recommendation. They're asking for a fragment of a sentence or a sentence to be added to section D2.
Oh, okay.
And it took me a moment, but I wanted to share with you, and the Alderman can confirm my recollection. What Chairman Waldman is saying is that he's saying a use which has ceased for more than 2 years must apply for a second extension subject to the standards. And what that means is that once the use has ceased and 2 years have passed, you're entitled to re-up your, extend your special exception, but you only do it subject to the standards. And what he means is that you've got to go back to the original standards for granting a special exception. And the Planning Commission has to find that you meet those standards still, because time has passed. That's what that subject to the standards means. That you don't get it just for good cause or for being persuasive at the hearing and asking for an extension. You have to have your experts there and present a case. I deserve to have this use reinstated essentially after it's ceased because it's consistent with the comprehensive plan and it won't have adverse impacts on adjoining property. It won't change the traffic dynamics in the area and all the other standards that are applied. So that's the distinction. It's subject to the standards. And a better wording for that would be subject to the standards for granting a special exception, which are listed in,
Takes you back.
cite the section of code.
right?
I accept.
Yeah.
I accept. Could you please get Ms. Ryder the exact
happy to.
appropriate language to put in?
Right. And if you feel comfortable approving it with that, we can actually cite the actual section right now in code, but that's what subject to the standards meant. It's a higher test for the applicant.
But they would have to go back to the original
Yeah, prove it to
standards
us
for
that
a
it actually
special
still
exception.
works. You've let this cease
Right.
for whatever reason has effectively ceased, you're entitled to get an extension or get it reinstated, but you have to do it according to the standards.
I accept.
So if I made a motion that the Rules Committee recommend favorably with the amendment, subject to, before it goes for a vote, the council, the refinement that the Planning Commission and Director Jakubiec were just talking about, be a refining amendment?
Well, we are acting now on the amendment, Schnellmeyer amendment to the amendment.
Right.
So could your motion be that we would accept the Schnellmeyer amendment as amended?
So moved.
Yes. Do we have the wording for the as
I
amended?
think he just gave it to Ms. Reuter.
Yes.
Yeah.
So,
Could you state it again for us?
Yeah. So it'd be in subsection D?
Subsection D, paragraph 2, or D2, a use which has ceased for more than 2 years must apply for a second extension, subject to the standards for granting a special exception set forth in section, and you'll have to fill in the section, but it's section 21.26.
Right.
I don't know what
That
the
was-
last two numbers
Dot,
are.
dot, dot.
on this page,
Yes.
wasn't it?
Yes.
No, the one that had the numbers on it, but he got it, I think. Okay. All right, so that's the motion. He made it, I did, you seconded it. Okay.
Right.
Further discussion? Hearing none, all in favor of the amended Schnellmeyer's amendment, please say aye.
Aye.
Okay, so,
Madam Chair?
yes.
I think it's great that the director's here, but when we're honoring the recommendations given to us from the Planning Commission, it would really be nice to have a planning commissioner here to help us explain their thinking. So whenever we're getting legislation that has gone to the Planning Commission, it would really be good to have someone from that body here as well. Because if you weren't here, Director, I'm not sure we would have found our way to the right place.
I'm very glad I did come to this meeting today. I wasn't going to. It occurred to me that I better get over here fast. So.
Well, thank you. And I'll ask Ms. Jackson if she could make a point when the Planning Commission is added, that they be invited to the meeting. You know, when we have all of our committees or legislations assigned to us, everybody knows where the legislation is going. And if they are interested in coming, they attend. But the Planning Commission's left out of that loop. So we'll try to make sure that doesn't happen. Good suggestion, Alderman.
Madam.
So now we're, Alderman?
Yes, I understand. I do think there would be value if they can make it. I do want to say, though, many of them have full-time
yeah.
jobs, so it may be difficult for them. But,
So do you.
I do, man, and my my attendance here is,
We have
I don't want to say spotty, but not as spotless.
Well,
But,
you have been here, and so not to worry.
I try my best.
And my request to Ms. Jackson was to invite them.
Yes.
It's not a mandatory appoint or assignment, but if they can, or if there's a representative even, could come and speak to whatever the legislation is, that would be,
Drive-through
that'd be
windows
great.
is next.
So, okay, so I'll entertain a motion to give a favorable recommendation to 03323 as amended.
As amended. Second.
So moved and seconded?
All right, all in favor, please say aye.
Aye.
Aye. And I think we only have one amendment, but he amended his amendment, so it was all good.
The Uber amendment.
Yes. Okay, going on, citywide prohibition on new drive-through windows, 0626. Alderman, you had a question about whether, no, this isn't the one you were talking
Nope.
about. So
Yes.
Alderman Schnellmeyer, you're one of the sponsors on this legislation?
Yes, Madam Chair. So update from our previous meeting, there was Amendment 1, which had caused some confusion. Just to kind of clarify, the goal of Amendment 1 was to try to clarify that existing buildings could still use their drive-throughs if a new business came in because.
Excuse me, I don't want to, I hate to interrupt you. No, there is no Amendment 1 attached. Is there Amendment 1 attached to yours?
Not anymore, but
Oh, okay.
I am getting into that. If folks will recall, in our previous meeting in Rules and City Government, there was Amendment 1, which was an Economic Matters amendment, introduced by Alderman Savage, myself, and Alderman Gay. And the goal of that amendment was to try to clarify with folks that that existing drive-throughs, existing buildings, if a new business came in, they could still use it because at the time, the Planning and Zoning Department believed that if a new business came in, that the legislation as written would not allow them to use the drive-through. However, coming into this committee, that had caused some confusion for the intent of the legislation. So we had postponed action on the amendment and on the legislation as a whole. And we went over that further in Economic Matters last meeting. And Planning and Zoning Department had come to the conclusion that the bill as currently written does not block existing buildings from using drive-throughs if a new business comes in. So, for example, we have the KFC the former KFC on Upper West Street. I don't know the business coming into it. I think it's an Arby's, but I could be mistaken. If this were passed, they would still be allowed to use that as a function of the building. So we had withdrawn Amendment 1 because it just added confusion, added extra work, and it is now as stands. So our rationales for the legislation still stands. As we go into the comprehensive plan process, drive-throughs, they space things out, endanger pedestrian access, they endanger cycling access. We know through our comprehensive, through the land value study that these are a heavily subsidized through land use process. They are either revenue negative after we factor in our infrastructure and city services process, or they are barely revenue positive if they are. Those are my arguments. Folks may disagree, and let's do it.
Alderman Arnett?
Thank you, Madam Chair. So I certainly agree with being consistent with the comp plan, and I agree that drive-through windows are definitely auto-centric. I would make a couple of points, however. In the Planning Commission report, they find that the grandfathering in of the right for drive-through windows is not explicit. In fact, they think that it prohibits drive-through windows writ large in the city. I'm not sure how we reconcile that, but I know the intent of the sponsors is not to get rid of all of the drive-through windows, and it is to allow existing drive-through windows in a building to be repurposed as a drive-through window. But I do have some concerns about whether that is explicit enough in the legislation. I did read the findings on the position of the planners, but I also read the equity report, and it lists 3 different concerns. They're demographic with different populations, demographic within regard to age, and demographic with regard to children. And I find that most of those, in my mind, apply to fast food drive-through establishments. I don't know that many children are banking or even picking up prescriptions. However, they might be in the car with a mother or children who are sick. So I think it would be appropriate at this meeting to at least have some recognition of the equity report before we make our recommendation.
So in regards to the existing use, that's why I'm glad we have the planning and zoning director here. Mr. Lashinsky was at our economic matters hearing along with the law office, and they stated that there's a little bit of back and forth between the two. Mr. Lashinsky said, we believe it is. We'll put it to the law office to verify. The law office says, the planning and zoning office says that it is. And if the sponsors of the legislation are also saying that it is, then it is. So as our planning and zoning director, with us as the sponsors saying that we intend it to be allowed if it is an existing use of a building and a new business comes in, is it still allowed?
Yes, it's still allowed.
All right.
When a city council makes a zoning change and it eliminates a permitted use, the folks that have that use still have the right to continue that use.
By constitution.
And that right is not expunged just because they transfer ownership. The right continues with the property, and it's called a non-conforming use. So it can operate as a non-conforming use, and it's subject to the provisions in the non-conforming section of the zoning code. So yes, those drive-throughs could continue indefinitely with this zoning change in effect, even though they change ownership to another entity or person.
And so in the future, there's not going to be a discussion between departments as to whether that remains. Because what I heard you say in the economic matters, when someone said something, somebody said something different, and there was not an agreement.
I don't think there's any doubt in my mind that these uses become non-conforming, and non-conforming uses are protected. And the change of ownership doesn't extinguish a property right. Our zoning deals with use and impact, and you don't lose the right to sell a house because it's a new owner. It's a use that's permitted, and a non-conforming use is a use that's permitted to continue.
Okay,
Yep.
thank you.
So the planning commission agreed largely with the sponsors and the position paper by the sponsors that this is inefficient land use. It's not consistent with a comprehensive plan. However, they did say the council may consider an exception for planned development. Director, it seems to me that in planned development, by force of being a planned development, the plan would consider the use of drive-through windows or not in a planned development. The real question, and Alderman Gay and I had a conversation, is for future undeveloped properties that are not planned development, that are single institutions, would it be, and I'm going to speak to one of the sponsors here on the committee with us, would it be reasonable to have an allowance of, particularly for banks and pharmacies, a special exception process where they would have to justify for a single retail outlet going through a special exception process to justify, and all of the considerations would get weighed in, convenience to parents with sick children, et cetera, elderly, so forth. So that is not in the current legislation. I'm not myself offering that amendment, but I am offering the conversation that Alderman Gay and I had about making any new non-planned development drive-through windows be approved subject to standards via special exception.
Alderman, could you name those again?
Well, the
You
two,
said pharmacies
and banks
and
are the
banks.
ones. I mean, other than pharmacy and banks, I'm cannot think of, and fast food establishments. I don't think we have drive-through liquor stores. So I'm trying to think. I think those are the three principal uses of drive-through in the city or anywhere. There may be other.
liquor stores if
Dri-
was on there?
I believe the scientific term for
Drive-through dry cleaners. Actually, Zips really does have that thing where you throw a bag with your clothes in it.
Well, we do have drive-through cleaners, Taylor Avenue.
That's true. So would they be covered under this legislation?
If someone wishes to build a new drive-through dry cleaner, that would be prohibited under this legislation. Or
Well, you
a
said a new one, not a
build a new one is,
It would be allowed.
if it is a existing one, it would be allowed. If it is building a new one, it would be prohibited.
I do think we have some people here.
But so they would not be allowed. A new drive-through dry
understand
cleaners
this-
would
this
not be allowed
ordinance-
unless it's being repurposed, a building's being repurposed for that.
Right, if it's an
Or as
existing.
part of a planned development.
Yeah, or as part of a plan development. Okay.
That's right. So this bill would eliminate all drive-throughs, all new drive-throughs, or just new drive-throughs for fast food restaurants?
This bill is meant to eliminate the construction, the building of new.
New.
Like what we saw with the whiskey, where it was torn down and a Taco Bell was constructed in its place with a drive-through.
And it would prohibit a bank from putting a drive-through window, a new bank from having a drive-through window.
If a new building is being constructed with a new drive-through, that would be prohibited. If a building already has a drive-through and a new bank is coming in and they're just going, this drive-through window is here, similar to the former Bank of America out on Bay Ridge Avenue, and a Chase Bank came in and they're going, this drive-through is already here, that would be allowed.
Well, that brings another question to my mind, because we're only talking about drive-throughs, and you mentioned the whiskey. And I remember when the whiskey was the library, and it only had one floor. Thank you, the teachers from local schools, for adding a second story to that building. That's a whole nother story. But there are cut-throughs there. There were when it was the whiskey and when it was the library and several things in between. And so I don't see that as repurposing. We put a Taco Bell where there were already road cut-throughs. So is the attack now just on drive-throughs? Or I thought it was to stop all the road cuts, the curb cuts, where people are trying to cross the sidewalk, and there's a curb cut there, going into whether it's a Taco Bell, or it's the whiskey, or a dry cleaners.
It's sorry.
Go ahead, I'm sorry, so I'm done.
Construction of new drive-throughs.
Of
Okay,
any type.
all right. Don't go too far, I'm not,
Yeah.
I'll step aside.
so, I'm going to call the gentleman up from the Bankers Retailers next, because they've been sitting patiently, as have all of you, to share with us. Please come forward. Your name and address, please.
Right,
And your
Robert
organization.
My office is at 186 Duke of Gloucester Street, just a block up the road. I think this is I appeared at the full council meeting, I appeared in your meeting, your last meeting, I appeared in Economic
Is the mic
Matters.
Would you make sure your mic is on, the green light is shining?
It's on.
Maybe
Is that
pull
better?
it a little closer
Yeah.
to you.
Is that better? Just two things I wanted to point out. First of all, I understand that ARP has weighed in with written testimony in opposition to the bill. And, they kind of mirror the same concerns that are raised by your own ombudsman, that this will have a disparate impact on the elderly, the disabled, and minorities. And I just wanted to make sure you are aware of that. So it's not just the bankers that have concerns about this. It's your own ombudsman, and it's ARP. And I don't know how often ARP weighs in on anything, but I think that's important for you to note. The only other comment that I would make, in looking back at the report from staff of the Planning Commission, they state that current standards require an applicant to prepare a traffic impact study. Any impacts must be mitigated. Another standard requires applicants to, quote, not negatively impact pedestrian circulation. Most new drive-through facilities are part of the development of a scale that trigger a major site design review. I mean, I just really question whether or not you don't already have sufficient protections in place in your current process. It just seems to me that for the whole city of Annapolis to have just a blanket, ban on any drive-through, no matter where it's located, no matter how commercial the area is. I keep coming down West Street when I come from home. I'm getting off at the exit where the mall is, and coming up West Street, and I'm just, until you get up to the library, it's just all totally commercial, and it's not quaint. It's not walk through. When you get up to the library from there and up to the circle there where the Westin is, that I could see, but I just would say that and I've spent a lot of time on this, frankly, but it's just the notion that we would have a bank that would want to open a branch in the city of Annapolis, but couldn't have a drive-through. I can assure you that bank is not going to locate in the city of Annapolis. They're just not. That's not what the public wants. And if you only have 5 branches in the entire city, none of them are in any residential space whatsoever, but why wouldn't you want another bank to come in to serve your citizens? There's such a marked difference between banking services and Burger Kings, and with all due respect, I don't mean to be negative about them, but our branches are typically open from 9 in the morning until most of them until 4 or 5 in the afternoon. They're not open on the weekend. They're open on Saturday. They're not open on Sunday. They're not open at night. They're not open at 8 o'clock when somebody has to go to work. And the drive-throughs are really, really important, I think, to people with children in the car, people where you have a disabled person in the car. And it just, to me, it would be such a limited amendment to exempt out the banking industry for new branches. They're still going to have to meet all the requirements. It just seems to me it shouldn't be that big a deal. One size does not fit all in this issue. So those are my concerns. They were the same concerns I've expressed before, but I did want to I came down today mostly just to make sure that you all are aware that there's opposition from ARP, which I find illuminating and unusual. I'm happy to answer any questions.
Well, thank you. I think we all received ARP's letter. I trust we all did.
Yep.
Any questions for Mr. Eden?
No, we've had,
Thank you very much.
Thank you. Anyone else that would like to speak? I trust you also received a letter from SOFO indicating their opposition to.
and from the Retailers Association.
I received a letter from Jennifer Balducci, not from SOFO.
Oh, I received one from SOFO. And Jennifer may have signed it, but if you read the bottom of it, she was representing their position. But I think we all got that. So lastly, I'll speak as chairman. I do have problems with this legislation, and not for anything different other than what we've heard. It feels discriminating to me. Well, first of all, I had a bank on Forest Drive that closed that branch and closed the window and moved to Bestgate Road in an office building. And that bank no longer exists in Annapolis proper, Annapolis County. It was a mistake clearly that they realized when they moved out of Forest Drive. And I changed my bank, as so did a whole lot of other people that I'm aware of. So I know it does happen. And I know the value of the drive-ins, whether it's to the seniors, being one myself, I get it seriously. The pharmacies, the parents with children. I think more and more we are not considering all of our constituents. And there are many many groups within our residential base that we have to consider. And so I don't think this legislation is considerate of all of the subgroups in the city, whether they're minorities, whether they're disabled. And I hate the fact that we don't think about how these things impact everyone. You know, the environment is important, absolutely. Safety of our children, which is, I thought, where this started with bicycle crossings. But everything has to be considered, and I really feel like everything is not being decided or considered. We've made our decision, and we're going to stick with it, and I think it's a mistake. So that's my position, and I'm sticking with it. Alderman Chandler-Meyer?
Thank you, Madam Chair. So one thing on the equity study and another thing on the return on investment. So I reached out to Ms. Raftovich, the drafter of the equity study, and just some of where these statistics are coming from. One was from the National Restaurant Association, so one of the primary opponents of this. So we can take that with a grain of salt, we can take it not without it, up to you. And the other was anecdotal evidence per her email. So again, there's value to anecdotal data, but we have to understand where it's coming from. And I understand these are a convenience. I understand these are a reliable source of services for folks. But we have the return on investment land value study. We know that these are a money loss for the city. And we're not getting rid of existing ones. We're just stopping the construction of new ones. We're stopping the construction of a development pattern we know loses us money. And that means we are stopping the construction of a thing that we know we have to subsidize. And that means, what services are we willing to cut from our services? What services are we willing to cut to subsidize this development pattern? What services are we willing to cut to subsidize McDonald's, to subsidize Burger King, to subsidize Chase, to subsidize Bank of America? Or what taxes or fees are we willing to raise to subsidize McDonald's, to subsidize Burger King, to subsidize Bank of America, to subsidize Chase? It comes down to that. We can provide better infrastructure for more people if we stop this cutting and adjust our development pattern. I understand there's often a chicken or the egg point when it comes to how do we get a more walkable, more mobile-friendly city outside of cars, but there's always this idea that we can seamlessly do it, and there really isn't. There's always a seam that shows at some point. So I understand where you're coming from. I think this will just be a point where we have a respectable and understandable disagreement, and that's okay. But that's where I'm coming from.
Alderman Arnett?
Thank you, Madam Chair. So we have this legislation, we have the plastic bag ban, we have the leaf blower, we have the comprehensive plan. Well, we're really starting to change our philosophy, and I understand the convenience arguments, but I also think we need to consider the environment arguments for these. There's no doubt that we are an auto-centric, starting with people my age. When we first had cars and went on our first dates and had our first kiss and went to dances with Dad's car and so forth. But we just have to start changing the mindset. And it is going to bring inconvenience. But it's also inconvenience to have global warming and sound pollution and all the other things that we have to consider. So in principle, I am supporting this because it is a statement saying that we are drawing the line that we have got to change the way we think about things and do things, recognizing that there are going to be inconveniences, in some instances more than others. I have a check for my brother to pay for part of the family reunion we just had. I will photograph it with my phone and deposit it. I don't need to go to a bank at all. So to me, no offense to the banking, I think that is also an industry that is changing. I don't think we have very many drive-through pharmacies. I do recognize people with disabilities or people with sick children not wanting to trek through the pharmacy to get their prescriptions. And if I thought there was a big glut, and if Alderman Gay follows through with an amendment to make that a special exception process, I will likely support it. But I think overall, it is time to start walking the talk. We've got to suffer some inconveniences in our daily lives if we're going to adhere to the bigger picture. If we do obtain the vision of the comprehensive plan, where we're increasing density along transit lines and having mass transit and those sorts of things, hopefully when we're planning for those, we'll be planning for these kinds of walk-up conveniences. It won't be a drive-up. You can walk up to a window in your planned community. But I just think it's time that we draw a line and say, we've just got to start changing our ways. It's going to be very easy to continue to do what we've done all along, but I'm going to vote in support of a recommendation from this committee to recommend favorably to the council.
Well, Alderman, I thought I was going to speak last, so I will have to respond to you. Don't have a problem with us changing with the times, and particularly as it addresses our concerns about global warming and us being a greener community. I have no issues whatsoever. My only concern is when the changes don't impact everyone. I think all of our legislation should have an equal impact across the board. Global warming is impacting everybody, not just the poor, not just seniors, not just people with young families. And I think any and everything that we do has to be considering those people who can least afford the changes we make. You know, those people who are going to be moving into the planned communities are probably not the people who have problems getting out of their car to walk to a pharmacy. There are some people who can only afford fast food for their children. And when they come, they have their children in tow. And the inconvenience, you know, at least a third of our population in the city are disadvantaged in some form or fashion. And you know, they may not have to walk up to the bank. They may not have a bank. You know, they may be going to the bank to get a money order. We can bank from our phones, you know, never have to go into a bank. But that is not too large a population in our city. And I think we are seriously undervaluing their needs. And, you know, the data changes depending upon who you're talking to. And I don't go by a grain of salt what I hear, but I do go by personal experiences. And so I think this legislation is going to have a terrible impact on the people who can afford it the least. And so for that reason, I am going to oppose this legislation. But I will entertain a motion right now to do what, or is there one on the floor already?
I'll make a favorable recommendation.
Second.
Okay, it's been moved and seconded. Further discussion? Hearing none, all in favor, please say aye.
Aye.
Aye. Nays, nay. Thank you for a healthy discussion. Okay. Going on to our next item, which is special exception, nope, that was it.
2024.
2024 elections surplus. We were having a discussion between 2024 and R43. This is the chicken and the egg. I see Ms. Leahy is in the audience. If you'll come up and help us with where we are. We had approved the first, I think, 3 amendments to the elections code. And this is the 4th piece that we had challenges with at the last meeting.
There were 2 sections, or actually 3 sections.
Ms. Leahy, could you give us your name and address,
Yes, Eileen
please?
Leahy, 110 Orchwood Avenue, 21401. Do you want me to just go in order of those, or do you want to start with the certain area?
You can, I think, gentlemen, what would you prefer? Do you want her to just go over the changes that we had requested?
I think that's good.
Okay. On page 3 of 5, under the heading A, timely reports required, there were some questions in regards to number 1, all reports or statements required in section 4.44.080 and section 4.44100 must be filed by the candidate, their chair, or treasurer during the 5 calendar years preceding the election in which the candidate seeks to participate. There was some confusion about what that actually meant. It is pulled from a section above it, so it's not exactly the same, but it's essentially the same thing that's currently in code. So this, even though I believe it's on your copies red, it wasn't intended to be a change as such.
May I ask you, is this a change, or is this originally from the original language?
It's a change in where
It's placed?
it's a change in that it is somewhat different than what's listed in A, in the previous A. So in the previous, which is crossed out, it has, let's see, I'm trying to find it. It's taken out of that, so it's somewhat shortened, if you see. If you go down on page 2, it starts on A, line 4. So it's lifted from there, all reports or statements. So it's the same language, it's just been pulled out. And I believe the previous part of it has not.
So it's taking place of A?
It's taking the place of A. It's if my recollection is correct, it's basically dividing that into 2 pieces and restating it.
Okay, and I'm going ahead a bit because it's going to be relevant. So B is taken from B?
Timely reports required on page 3 is essentially the same as section A on page 2.
Okay, so A is replacing A, B is replacing B, C is replacing, shoot,
I don't,
just lost it. I'm sorry. Alderman?
I don't think that's correct. I think the old A, which is showing up on page 2 of 5, that is stricken out, I can't find it. This is really talking about a person may not become a candidate for public or party office in any election in the city. A certificate of candidacy may not be accepted on the person's behalf. A person may not become a treasurer candidate, and it goes on in that vein. I don't see where that's repeated elsewhere in the things that are in red, because the new red on page 3 of 5 is timely report. So I'm trying to figure out, I do see in the strikeout the 5 calendar years, which I question the 5 calendar years. Do you have?
What letter was that under? 'Cause I
That's
kept-
under the old A on page 2 at the last sentence.
Yeah, if you look at the old A, starting on line 4, it says all reports, and it takes that language and it becomes the new A1. And then the previous sentences, a person may not become, it has basically been reworked to become number 2.
So my old A starts on line 19. So you're going up to line,
I'm going down to line 22.
On page 2?
Yes.
Can I help you out a little bit here?
Please.
So the A does correspond to A, B corresponds to B, all the way down. The original A is a massive sentence, and it's a very convoluted paragraph. And in legislative writing, you have a saying, it's like, we know what it says, but what does it do? So we took another look at that paragraph and boiled down what does it do, and it's totally rewritten so that it's understandable to everybody. The purpose of the paragraph is the same. But the writing was, usually when a section is black, it's just reformatting with some copy editing. This was a total rewrite of A.
so.
But the elements in A are still in the new A.
All right. My fundamental question is this not resending, first of all, if you're a new candidate, 5 years means nothing. And even if you're a candidate that's running for a second term, you only have 4 years of data. But is this not data that has already been reported and supplied to the city? So why are we asking the candidates to resupply that?
We're not.
Okay, so I'm not understanding
No.
that.
So they had to have filed the reports. So it's all reports or statements required must be filed by the candidate, their chair, or treasurer during the 5 years preceding the election in which the candidate seeks to participate. So if you didn't, for instance, if you hadn't done it 2 years ago, it's basically saying you have to do it. You can't just skip a year. It also helps to address we have a couple of candidates who still have open campaigns but aren't currently running. So it's basically saying you have to keep filing your reports every year, whether you're actively pursuing an election spot or not. Doesn't mean you have to keep all of your files. You're correct. The elections office does keep those files for 5 years.
So isn't it really saying that if you have not appropriately filed at some point in time, last year, 5 years, 10 years ago, you're not eligible to run until that's brought up to, I mean, wouldn't that be a much more direct way to say this?
It could be, and again, we weren't looking to change specifically that area of the code. We were looking to try to make it actually a little bit clearer. So the verbiage is pretty much the same. It's not something that I think the current board is particularly concerned about, but I can appreciate that it may be not as clear as it could be.
Yeah, all right, well,
Well, let me ask, is it the title that is confusing? The order is out of line for me, because I would have put 2 before 1. I would have talked about what's required of the candidate before I give the filing requirement. But that's just me. But timely reports required. I thought this was talking about the initial filing that is required of a candidate. That's the first part of the original language that I'm looking at. The second part of that paragraph speaks to reporting. Or maybe I'm,
It's not necessarily, it's just reporting deadlines. I think it I mean, we're talking about deadlines for all reports that are to be filed.
so maybe, I don't know, would that clarify it a bit if we change
Well, I
that
thought,
title
yeah,
to?
so, but now we're getting into Rules Committee amendments to the ordinance, which I'm more than happy to do, but I agree with you. The order there is part of the problem. You basically, what we're saying is if you haven't complied with the campaign filing rules in the past, you can't file to run again until you've addressed that. And that could be just filling in the reports, it could be paying fines, it could be a whole bunch of things. Who knows? But it is a screener saying, if you have not been a good candidate in the past because you haven't followed the rules, we're not going to let you run again until you address that or mediate that in some way, or we're not going to let you run again. I mean, suppose they can't fill in the 5 years ago because they don't have those records. The city might not have them either if they didn't file, but if they did file, the city would have them. So it seems kind of onerous to get them, they have to go back and file again with the city. But the real point, if I'm understanding it, is, and you're right, the name timely reports required, it could be more correctly eligibility for candidacy. And one of the eligibility requirements is you've filed all the reports that you were required to file in the past. And then point two would be, if you haven't filed them, file them now. And then I think the Board of Supervisors can drop down to B and say, if you didn't file it 4 years ago, you may have some fees due, which, think about 5 years worth of daily fees. But it's confusing to me.
So could we, or if you have an interest in amending this, to first of all come up with a title that's more helpful in defining what that's talking about, and then reversing numbers 1 and 2 under A. Caitlin, are you getting, please, thank you.
So I'm testing this out. And first of all, as I said the last couple of meetings, and I respect the job that the Board of Supervisors of Election has, and I respect the job they've been doing. So I'm not a fan of trying to micromanage, but I am trying to understand what it is we're doing. And so it really seems to me that A's title is something more like filing requirements. And one of the filing requirements is you've filed timely in any prior candidacy periods. And if you haven't filed timely, then the current one would be you have to go back and clear that up, either by filing or whatever. But, I mean, that gets into a huge level of complication.
Then, excuse me, should the heading be filing requirements, timely filing requirements?
Well, that's what it is.
No, timely reports
filing.
required.
Well, that, I don't know. I throw that out.
Ms. Leahy,
I mean, filing requirements, I think would be fine. I mean, it's,
timely filing requirements, or just filing requirements?
well, it seems that the timeliness has been something that you're not as comfortable with. So, I mean, filing requirements would be more broad, but would still cover that area. I mean, the previous version didn't have a specific heading.
Right.
All right.
I'm comfortable with timely filing
Fine.
requirements. That does indicate that there's a time restriction in some form or fashion.
Right.
But there are no reports. I mean, there are, but I think timely filings is,
And 5 years is what was in there in the past.
right.
You and I have obviously filed more than 5 years
I think so.
worth of data.
3-4
But
times.
I guess that's a sort of a statute of limitations. If you didn't file 6 years ago, you get away with it, but 5 years ago, no.
Better check. I mean, we may not be legal sitting here.
Hey, I'm leaving.
Okay, so does that, I know you were concerned, Alderman,
Yeah.
about the 5 years. So does that
Yeah,
better clarify?
I think so.
Okay, so that's part of the Rules Committee amendment. To change that heading and to reverse numbers 1 and 2 on lines 22 and 26. And are we comfortable with the late fees section?
No.
Okay, tell us why.
So, as I said at the last meeting, first of all, I understand that we need for people, for transparency in elections, to file and to file when they're supposed to file so that everybody can see what everybody's doing. But in my view, it is hard enough to get people to consider running for election. It is essentially a volunteer job. We're available literally 24/7, 365, although we're supposedly part-time. And our treasurers are clearly volunteer. And so anything we do to make their job more than the minimum requirement, more onerous, is not something I'm really positively disposed towards. So, and then the final thing is, again, this, and I think it shows up again on the second page, the failure to provide information. A daily fine, fines up to $500, filing of a misdemeanor filing are pretty heavy-duty kinds of implementation, what would you call it, incentives, whatever. So I question how heavy-handed this feels, and I will just say, to me.
Can we take these two so far?
Sure.
So we break them up?
Yeah.
And I thought you were going to respond to payment source on page 3, because that was one of your concerns the last time.
I was also,
So, Ms. Leahy, could you speak to, what was your first point now? I've lost it. On page 3.
The filing fee on line
The fee.
31.
I thought that was your second one. I thought there was another one. But the fee, was that part of the state? I know we were lifting from the state their requirements.
Okay, so currently, there is a late fee associated with the initial report when it's put in. But there's no late fee associated with amended reports. And so one of the things that this seeks to do is it does attach a late fee to an amended report. So an amended report currently has to be filed within 30 days. Many of the amended reports don't come back to us in 30 days. So this was meant to be more of a incentive more than, punitive as such. So it's also trying to make it consistent. So treasurers or candidates don't have to think in terms of initial reports and amended reports. By and large, all of the candidates, by and large, get theirs in on time, especially for the initial. There's really very few late fees that are actually put forth. This is the board's a way of trying to make it consistent, but also to encourage people to get their amended reports in. And this is of particular importance as we go into an election year when the reports have to come more quickly. Because, as I think I may have mentioned earlier, you could have report A that has a math error in it. And unless it's corrected before the second report is due, the second report's going to be in error. So they go all the way down. So it's not meant to be punitive. And we do remind treasurers and candidates that these are coming up. We're always available for assistance. Many times, what happens is it's not an issue unless, most of these issues sometimes get to be big issues where we have candidates, particularly sometimes a losing candidate, that just stops filing. And we have very little recourse to do that. And so those are the ones that go up to the $500. The $500 ones that accrue, and we're literally talking about maxing, I mean, that's max out. We've literally had some that haven't filed in over a year. And this is, you have to, so it's not very common. Most of the late fees that usually happen are maybe $20, $40. None of the, again, this is not a change in code. It has been written in code that candidates and campaign fund entities cannot pay fees directly or indirectly from campaign funds. Historically, it's not been considered consistent with the purpose of a campaign, which is to elect the official or to elect the candidate. We did discuss it at our last board meeting and felt that we wanted to continue. We didn't want to change the code at this juncture. Like I mentioned, the view is that late fees for an action of a candidate or treasurer is not a campaign reported related expense. And the board actually was trying to respond to comments about this section by putting into place or proposing a mechanism that a request could be made to waiver that fee. And that's what is on the second page or on the following page. So if you have a late fee, you can ask the board, hey, there was extenuating circumstances such as the treasurer or myself was in the hospital or there was a death in the family. So it actually gives an opportunity. We don't have that opportunity right now. So it was meant to try to balance it actually. So keep it the way it is, but provide an opportunity for a waiver. If we change it so that, it can be changed so that it can come out of campaign funds, but then the question comes, are you going to give waivers to campaigns? And what process would that be?
So, Alderman, does that satisfy your concern, or is there amendment you'd like to see taking place?
Well, at a minimum, is this new form, is this a new form, and if so, should it be mentioned in the legislation?
Well, that would be moving on to, on page 4, going down to line 27, the fee waiver.
Okay.
So actually, so it allows that a candidate may seek a fee waiver, and they shall submit a sworn statement concerning the candidate's financial condition and fill out a form provided by the election board. That's where that form came from. And then the board may conduct a reasonable investigation of the facts in the form and determine the need to grant a waiver. So
this would accompany their sworn statement?
that would essentially be their sworn statement, because at the bottom they say that that information is.
Okay.
Now, I would like to mention something that we did notice in review of this, that it would probably be prudent on line 30, after candidate's financial condition, to add or
Which page?
extenuating circumstances.
What page?
Oh, I'm sorry, page 4. Page 4, line 30.
And what were you saying?
So currently it says candidate's financial condition, and the board realized we probably should have in there the addition of or extenuating circumstances, because the extenuating circumstances may or may not be financial.
Right.
And the current form does list the type of extenuating circumstances that, might be applicable.
So is this the candidate's financial condition or the campaign's financial condition?
Well,
Is
it's
this getting into personal finances of the candidate or of the campaign?
Well, the candidate is the one that's expected to pay the late fee.
Okay, so as it pertains to their inability to pay the late fee,
Right.
that's what we're talking
Or
about.
it could be, that could be struck and just say extenuating circumstances, and that could be one of the things that's included.
Okay, because I think that could be misconstrued, to be honest with you. Alderman Chandler?
Thank you, Madam Chair. So I may be in the minority on this, I may not be, I don't know. I think that the late fee, where I would like the late fees to be is on the campaign itself and no waiving or grace given. I see the inability to file properly as a reflection on a campaign's general organizational structure, and the campaign pays for that. Coming out of the candidate's pocket, I don't know a candidate's individual financial circumstances. I don't know if they're able to easily pay it without worrying, or if they're going to be put under crushing burden. I see this as an extension of a campaign's operation, and that's where it should go. And that's why I also think the enforcement should be hard and swift and not flexible. So I strongly disagree with this portion of it. Everything else on this portion, though, I am quite comfortable. I don't know if my colleagues agree or disagree. But
Well, just let me clarify. You think that there should or should not be on page 3, line 37, candidates and campaign finance entities cannot pay directly. You think that should be stricken?
I believe
Drop 4.
candidates and campaign finances entities cannot pay fees or directly or indirectly from campaign funds. I think that campaign funds should be the entity that pays the fee. But I also believe that there should not be any leeway.
Okay, let's take one at a time. So in line 37, we can say candidates and campaign finance entities can pay fees directly or indirectly from campaign funds.
Correct.
So is that a motion to, this is all part of the big amendment from finance, from the Rules
Yes.
Committee.
I will move to make that an amendment.
Alderman Arnett?
So I will second it, but what do you do with B then? On the next page 4. I don't know, why do we have to cite payment source at all? I would just drop 4.
Good point. That's a much easier,
Repeat, well, first of all, can we take the first one that we already have on the floor to, you're saying just to delete 4 completely?
Right,
So it doesn't speak to where the funds come from?
right. But then the second part that the alderman is saying is,
Personal liability?
we don't do the waiver. Is that what I hear you saying?
yes.
So on page 4 of 5, you would drop mandatory and exceptions? I mean, would you drop that whole section E?
Wait, can I slow just a moment? I just want to be clear on the first. Your amendment was to simply change 4A on page 3. Your recommendation is that we eliminate all of 4 from 36 over to page 4 to line 2. Is that correct?
If you just change A, it'll be inconsistent with B.
So Alderman Schneidermeyer,
Well,
payment source. We can come back to you if you want to. This is a lot of.
a lot of moving parts here. I am understanding where you're coming from. I am looking at all this. I think the easiest thing is to remove 4A, keep 4B, but retitle it. And that way we guarantee there is someone on the hook to make the payment, but we allow for the campaign to be a payment source.
But B says it's the personal liability of the candidate
And treasurer,
and treasurer,
Okay.
not the
not the
campaign.
campaign.
Okay.
Sorry.
So I think in that case, that's a good point. So I think what you said is the better way to go
Just
about
drop
this.
4.
Just drop 4.
Okay, so your motion wasn't seconded. So do we have a new motion
New motion would be to drop
to
4.
eliminate page 3, lines 36 to 38, and page 4, lines 1 and 2?
Correct.
Correct. I will second the motion to eliminate
Can I
4.
make a comment?
Ms. Leahy, may I ask you to comment on,
I just I'd like to comment and just make a note that the Finance Committee did unanimously were favorable for this. This was actually discussed at Finance, and they had an opposing, had a different view.
I don't
of it.
remember what we did with this. Did we
was
make that
favorable.
change?
It was favorable, and one of the aldermen in particular, it was not changed, and
Okay.
one, if not two of the aldermen at that time were very strongly in favor of keeping it as it was.
Well, and we have two,
I
three.
know, I'm just
Yeah.
wanted to put that forth, because again, this is not a change that the board is proposing, it's something that's been there. And we'd just like to say, if it is changed, there will probably be other changes that need to go into this component, because we're shifting it to the campaign and not the candidate. So for instance, I would want to ask from the Office of Law, if the campaign doesn't pay it, will the same types of things occur? So if the campaign doesn't pay the fee, where does that leave us? Because right now it's addressing the candidate.
I mean, that's a good point,
Yeah.
which is,
I mean, one would think that the campaign would pay it, but again, you're changing the focus of who is responsible.
So let me ask, then can we simply use A and take out B? Which, using A with the first
As amended.
motion, which would make it, it would say candidates and campaign finance entities can pay fees directly or indirectly from campaign funds. That was the original motion. And then we went over to page 4, 1 and 2, these fees will be considered a liability of the candidate and treasurer. If we took out that sentence, and I'm not sure the law department's going to agree, because then there's nobody that's liable for the cost.
well, the campaign itself is.
So yeah, you're right, because it doesn't speak to the campaign. And so can we go back, can we kill the amendment that we have now, which would eliminate all of 4, A and B, and go back to the original amendment that would simply change A, but we would also eliminate B? It's so convoluted.
So on the floor right now was a motion to eliminate all of 4, but we don't like that anymore, so we're going to
So
vote that
I'm
down.
gonna call for a vote on that, and we're gonna defeat it, and then we'll go to the new motion. So a motion on the floor is to eliminate all of 4 on pages 3 and 4. All in favor? All opposed?
No.
Aye. The motion failed. So now I'll entertain a new motion on the same language that will speak to A, reading candidates and campaign finance entities can pay fees directly or indirectly from campaign funds, period.
And drop B.
And eliminate B, that's why I said it, period, that's the end of all of 4. So B is eliminated.
Okay. So you made that motion?
No, I made it for you.
Then I will make that motion.
Second?
All right, any further discussion? Hearing none, all in favor, please say aye.
Aye.
Aye. Okay, Alderman, going on to the, is it mandatory exceptions you were concerned about?
Well, no, I think
Oh.
now it's fine.
And then I thought that we should, since we now allow campaign funds to be used as a source of payment, now our fee waivers should go away, and we are now harsh judges and critics of sloppy filing.
Alderman, I have to say, once you've been doing this for a while, and your treasurers might change over time, and they may have different, I don't want to say hardships, but business.
Or you've lost them because it was too much work.
Exactly. I don't want to deter anyone, but that's the reality, so.
All right.
So you're suggesting that we eliminate on page 4, lines 27 through the fee waiver completely?
That is what I was suggesting, though it appears I am alone in that suggestion.
Alderman Arnett, do you have?
A hearty yes. A hearty yes to that. I am alone. Okay, cool.
So that's not a motion, is it so?
It be that way.
Okay.
Except,
Okay, so we're going to leave that as it is. So we have two amendments, Ms. Jackson? Would you remind us, or three, two?
Just one.
One, but with three,
Excuse me,
two separate
Madam Chair?
pieces to it. Ms. Leahy, I'm sorry.
yeah, again, I'm just for clarification, the fee waiver is focused on the candidate. You've now allowed the candidate to use campaign funds, so I'm unclear as to the relevancy of the fee waiver, given the new amendment on the previous page.
So should it be changed to the candidate under line 28, a candidate or the campaign? Who's gonna, if we put it
Well, but
on
who
both?
speaks for the campaign?
I mean, you've now
Isn't it
allowed the
candidate?
campaign to pay the
Yeah.
fee.
But the
So if
candidate
campaign
speaks for the
doesn't-
campaign.
If the campaign, can the campaign ask for a waiver?
Can the campaign, you're saying,
Not currently, not the way this is written.
do we need it if the Alderman Arnett is saying the candidate speaks for the campaign? So is this still accurate? A candidate may seek a fee waiver? May seek a fee waiver for the campaign? I don't know.
I think it's requesting a waiver for something that's, it's, I don't know. I think it's a bit of a moot point.
Back to harsh judgment. Back to harsh judgment. I understand where she is coming from.
I mean, the only other thing I can think that would be something that could happen, probably wouldn't, was if a campaign didn't have the money to pay the fee. Which, in that case, you might say that if the campaign is unable to pay the fee, then it is the responsibility of the candidate.
Would that be revealed in the statement? You said the fee waiver represents the statement, but if, I don't see here anything that says it's a hardship.
Well, that's where we were saying you might want to include or extenuating circumstances. Again, this fee waiver was put into place to try to balance what you've just stricken. So.
Well, by guaranteeing, still we have personal liability for guaranteeing of campaign funds, or fee waivers, or fee payment or fine payment. The campaign's broke and the candidate's broke or has hardship, I guess we can keep this in.
I'm not clear. We can keep this section on fee waivers in, is what you're saying?
Since we decided to keep the candidate is ultimately responsible for the payment of the fines, even though we allowed the campaign funds to be a source of fine payment. Let's say a campaign is flat broke and the candidate is going through a financial hardship of some kind. Maybe allowing the fee waiver in is.
I mean, I guess you could say you're allowing the candidate to use campaign funds. You're not forbidding them from doing it personally.
Right.
So if a candidate has a $100, let's say, late fee, and they say, yes, my campaign could pay for it, but I don't think it should because the reason it was late was because the treasurer had a family emergency. If in that instance, I could see the case for keeping a fee waiver because the candidate could make the case for the campaign. He doesn't think it should be paid regardless. In that case, I could see where you would keep it. But it would be the candidate then would be requesting it so it could be the candidate requesting it, the waiver, whether he pays it or he or she pays it or the campaign pays it. But again, I would include, if you do keep it, to include or extenuating circumstances.
And where would that be?
That would
One?
be on line 30. after candidate's financial condition or extenuating circumstances, or you may just want to say, just keep extenuating circumstances. It could be the
Right.
candidate shall submit a sworn statement concerning extenuating circumstances and fill out a form provided by the election board. I mean, it's
Yeah, I
really up
think
to you all in
that's-
terms of
Yeah.
how it.
I wasn't comfortable with the financial conditions.
Yeah, so
Anyway, so that's.
And the form allows for explaining what the extenuating circumstances are, 3 different kinds of reasons. So I would make that motion to amend the language on line 30 to say concerning extenuating circumstances. I do like filling out a form where you're certifying the veracity.
Okay, so Ms. Jackson, did you get that on line 30, candidates? Say it again.
So
Extenuating
extenuating
circumstances.
circumstances, which could be financial, could be other.
And fill out a form provided by the election board. We're keeping the rest of that, right? Okay, so there's a motion on the floor. Would you like to make a second?
Second.
Further discussion? So Ms. Leahy, you think that satisfy your?
Whatever makes you all happy.
Good answer. All in favor,
It's
please
the
say.
first person that's ever said that to us.
That's what my husband says to me all the time.
Smart man. All in favor, please say aye.
Aye.
Aye. Okay.
So do I need to make a motion to recommend favorably with the Rules Committee amendment?
Well, did we vote on all of the amendments separately, right?
Yeah, we
Or
did.
should we vote on them all together?
Is this one amendment or is this 3 rules amendment?
I was hoping we could make it one amendment. What do you think?
Well,
We
so
already voted on them.
So we've
We
already
voted on them
voted on
separately.
So we
it.
just
So,
need to
okay.
vote.
So
Recommend
as amended.
Yeah. Recommend O 2024 favorably as, with the Rules Committee amendments.
So moved. Second.
Okay, further discussion? Seeing none, all in favor, please say aye.
Aye.
Aye. Thank you. Hitting the wrong off button. Okay, that leads us to R 4324, fee schedule updated for Title IV elections.
I move we recommend favorably the fee schedule.
Do you want to discuss it or?
Well, if you don't want to, I think I concur with, well, I don't know, I want to hear the discussion. It was moved, but I'll second it for the sake of discussion. The fee schedule requires a $20 late fee for all campaign reports, including amended reports that are required to be submitted. And then a maximum
And that's
fee,
daily.
and that's a daily per report. And then there's a $500 maximum fee. Is there no indication when that kicks in? What's maximum?
After $500 worth of daily fees.
Oh, is that what it
500,
is?
It stops.
You have $500 worth of daily fees, and then it turns to $500.
But once it's $20 a day up to 500. So once it hits 500, then it stops. You don't keep accruing it. So it gives you 25 days to be late. That's your, so if you're late for 25 days, you've accrued $500 in late fees, but it doesn't keep going.
And then after, it doesn't keep going. So then so why is this necessary, the maximum? I guess to just say you can't charge them after 25 days?
That's what's in the existing code now, which is 500. It's, in current code, there's a pre-election and a post-election, and so in pre-election, the maximum is $250. And in election year, in pre-election, there's a maximum of 500. In a post-election year, it's 250. We wanted, again, be consistent. It's unclear how you define pre versus post-election, because once the election's over, one could say, well, you're pre for the next election, and some say post. So the rationale was to make it one, and so all reports would have a maximum fine of $500.
So shouldn't it be consistent at all levels? Shouldn't it be 250 no matter what? I mean, if 250 is,
We took the 250 away and made it 500. So you have,
when are the 250s kicking in?
currently, for post-election, so for instance, if you look at the election year started, say, August 2024, so the election year going into 2025, one could construe and say, okay, we're in an election year. So the fee then would be $20 a day for a maximum of $500. If you're in a post-election, so let's say these were incurred last June, okay, that would have been considered a post-election, and that would have been $10 a day for a maximum of $250. And so because it's unclear, we don't state or define what's pre-election versus post-election, the thought process was, let's just pick one. And so the one we picked was the $500.
Okay, and this doesn't speak to post-election and
It's
pre-election, I
all
think.
reports, whether
Okay.
it's pre or post-election. In my 10 years on the board, I think we've had it happen twice, that it's gotten to that level, and both were losing candidates. That
Both were what?
both were candidates who had lost the election and then stopped filing reports.
Did they ever pay?
Yes. In one case, we were actually getting ready to file a misdemeanor in circuit court. And that's why we needed that. And once we gave notice that we were filing, we received a check.
So that's when it was 250.
That's when it was $500.
Oh, it was $500.
It's a
Okay.
$500 fine. It happens rarely, but it is something that is sometimes necessary. I would say most of our late fees are $20, $40.
Not going with, never mind. I have to figure that one out. So is there, Alderman Chandler?
I'm happy we discussed it. Seems cool.
So are you, was there a motion? Did you
Yes, I made the motion.
Second.
And you seconded
make-
it.
Okay. So the motion has been moved and properly seconded. Further discussion? Hearing none. All in favor, please say aye.
Aye.
Okay. All right, and our next piece of legislation.
Thank you.
Thank you,
you.
Ms. Leahy, appreciate it, for both visits to us.
I'll be back.
I'll be back, uh-oh.
Hooray.
We're
I
all
hope
getting-
it's easier.
This was not the one I thought was going to be hard.
Uh-oh. Okay, so the next item, R4626, Task Force to Study Residential Marine Vessels. Alderman Arnett, I know this is your legislation. So
It
no,
is,
yours and-
along with Alderman Savage.
Mm-hmm.
I think it is necessary. I'll just ask the committee a couple of questions. Do we have any of the reporting that was required from the city that was required when we passed 02521?
Alderman, you know the answer to that.
Yes, we do not. Do we know the number of slips in Annapolis?
I think we do know that.
I don't think we do.
I think it was provided to us at one of the two meetings that we had, but maybe
and-
my memory's
right.
foggy, so
Well,
we
I
can
think
look at
we've
it
had
again.
various, do we know the number of slips by marina?
Well, I think that's how the 1,600 or so was gathered, based
No,
on,
it was gathered as an aggregate number, but there's another count. So, I mean, the point is, this legislation is boiling down to its simplest form, going to be to allow a percent of the number of slips in Annapolis to be occupied by houseboats rather than recreational boats. And I think we need to know that very basic amount of information. If the administration can provide that immediately to the task force, wonderful. We're way ahead of the game. I do think there are other impacts of the potential legislation. I say potential legislation because we had draft legislation introduced and now withdrawn. And there were a lot of aspects of that previous legislation that impacted more than houseboats. It impacted liveaboards. That's why we have the liveaboards speaking to us and so forth. I really believe that we need to gather the kinds of information that this resolution requests in order to more fully understand what I do with my copy of all of the impacts. And the legislation has three overweening areas of focus. One is maritime, which includes marinas and mariners and all the boating community. One is community impacts, which includes, again, recreational boaters, but also communities where these houseboats would be. And then really of concern is the impact on the city in terms of the additional amount of staff required to monitor various things. So what we heard from the proponents is they're not going to lease these houseboats, they're going to charter them, which brings in the Coast Guard and all the chartering regulations. And I doubt that we know what boats in the city of Annapolis are Coast Guard certified. And there's different levels of that. It's certified for documentation, it's certified for requirements if it's a 6-passenger or less, and more than that, and so forth. So this is an attempt to find the information that we will need to know when we consider the legislation when it's introduced. And I think it's incumbent upon us to have this kind of information.
Alderman Shannon, do you have a? I'll speak if you're holding.
He's speechless.
Look, I'm not ready to vote on this today. I'm gonna be honest. I'm a little nervous on this. I've had some folk from the Living Board community come up to me with some real fears that this is going to be used as a roundabout way to ban them. I've gotten some comments calling liveaboards floating trailer parks and floating ADUs as a negative way. And when that's thrown at me, a guy who's lived in an ADU and had to live in a trailer park for a little bit, I very much see where they're coming from. And I can't help but see that some of the people might want to use this as a way to push something forward. So I haven't had time to dive into this yet, and that's part of the reason why I'm not ready to vote on this today. And I apologize, it's just my own time management issue why I haven't had time to dive into this yet. But look, I understand values of task forces, I understand the values of data, I love data, but today I don't feel ready on this. And when people come up to me with very real fears that where they live is going to be under attack, and when someone calls that place a floating trailer park, that sets off a whole lot of alarm bells in my head, and I get it. So I'm not saying no overall, but I am saying no today, and I hope that makes sense.
Thank you, Alderman.
You will have an opportunity on the 6th of November, because that's when this comes before Economic Matters.
Well, it's going to come back here too.
Yeah, it's going for Economic Matters too, and we'll dive into it deep there too, but I'm just telling you where I'm at today, mate.
It's a shame we can't have more joint opportunities. But I concur with you, Alderman. We're not ready. I was surprised that it's on our agenda, but they just had agenda review on.
I was surprised too.
Well, they just had the agenda review on Wednesday, and I got a call that it
We
was
do
on
have
there.
people here who've been.
I'm going to give them a chance. We're having a discussion right now.
Sure.
But, you know, I think there is a lot of information that needs to be gathered. I think you're absolutely correct. I find it still very unfortunate that we had to take this route, because I truly believe we could have gotten the information in a different fashion without it being so divisive now. It has become a kind of a discriminatory piece of legislation. Again, I used that terminology in the previous legislation. We should be looking at things that are inclusive so that large communities within our larger community feel that this is home and they're not being shut out. And this is what concerns me. I brought this to your attention because several people brought it to my attention, and I had no idea that we would open up, and not a can of worms, but we would not allow everybody. We could have had, the harbor master and she sent us the numbers. That's how we got the number of slips in the city. She gave us data, but it's grown. And on top of it growing, the deadline for a year when all of us are gone, which is a great way to kill a piece of legislation, because we can't pass it on to the next council to approve. They can do their own due diligence, but it just feels not right that we can't have this discussion. We did it with the Public Works facility. I mentioned that to you. We did a task force, but I selected every professional that I thought would be involved in that facility, from land use to roadways, you name it. There were 22 people on that commission, and their work was done, and Jared Lippman was our chairperson for that. And they did a phenomenal job. It can be done, but we have to make sure that everybody who's on this committee has a professional knowledge of this subject. I think we need definitions. The difference between a houseboat not being recreational, I'm sure that there's nothing that says houseboats are not recreational. So to cause that division is just, so I'm glad that we have an opportunity and to not just kill this. We are going to amend it in some fashion to change the timeline, probably in my pleasure to 6 months, so that there is adequate time for the council to write legislation, for the committees to contribute to legislation, because the law department wrote legislation on this. That was exactly not what the mayor wanted. And it was sent back to the law department. And we were supposed to get a new copy, if you recall. And we were supposed to sit down with
hasn't
the
been
corrections, and it never happened.
No, it hasn't been drafted.
Well, I don't know. But it was supposed to have been drafted, and we were supposed to revisit it in September. I thought we had a date, but maybe we didn't. And so that broke down, so instead we get legislation. So that's why it's so disturbing to me, because we could have gone another route. But we're going to make this as divisive as we possibly can, it appears. And that's unfortunate.
May I please respond?
Please.
First of all, we had a task force for the major maritime. We had a commission to look at the location. Again, a body of people that took time to do the fact-finding, sort out the pluses and minuses. We have an ongoing group that is looking at the issues of small marinas right now, concurrent. This is no different than those three bodies. This is asking for the same thing. I am open, as I said at the council meeting, if we have all this information and we can get it next month to this body, hallelujah, we can move on. So I'm not opposing changing the deadline. I didn't think about that when we worked on the drafting of it. I didn't realize the end of our lives was coming up so soon.
Don't put it like that.
So, but I think getting the information, I don't think I would use the word divisive. I think I would use the word a broad spectrum of concerns. We're going to hear from concerns. I had coffee with a number of the liveaboards yesterday. It was yesterday, right? And I think it is bigger than just one or two houseboats in a slip. And I also think that there are details within it, like one or two houseboats parallel to the shore or perpendicular to the shore. I think there are environmental things, pump outs. There's all kinds of things that I think we need to get professionals. I've had 2 commercial vehicle people volunteer to be on the committee to look at this whole commercial vessel certification. So I don't think there's anything wrong with doing with this the same thing that we've done with so many other issues. And I don't think it's divisive. I would rather label it inquisitive. Let's find out what's going on. Let's find out what's being planned. So that would be my argument for this. But if we need to take more time on this body, I'm all in favor of taking the time we need to address these issues. There are 5 bodies that this legislation sends it to, and this is the first, but it's also going to the environmental matters, it's going to economic matters, it's going to Maritime Advisory Board, and it's going to the port wardens. So there's going to be a number of bodies, and many of them, I might add, may well be providing us with the information that the committee needs to, the task force, give us in 6 months or whenever to help us formulate an opinion on this issue, which is a bit different than just putting another catamaran in a slip. It's much different.
And if you remember, in one of our, I think it was our second meeting, there was a discussion about how we should change the code and what the options are. And, you know, so the fact that we had talked about, and we had already agreed that catamarans did not fit because they're no larger than some of the houseboats or something similar to that. But we talked about coming up with options about where they could park, dock, or whatever. So we had considered so many of the things, maybe not everything, but we were looking at what the consideration should be. And so I think, and I hope that on this task force, we do our due diligence to bring in all the experts in all of these categories so that we can have all the opinions at the table. Because I don't want a one-sided discussion here. I want to make sure that everybody who's, I mean, I don't know, everybody here, you've listed already, but I would hope that we would add additional people so that we are assured to have a well-rounded discussion. But as the Alderman said, I'm not ready to list, you know, make amendments to it at this point either.
I understand that. On page 6, it calls for 15. That may be too small, and it does call for a wide variety of groups, but no overweighting of it. The meeting we had was with 4 marinas, their attorney, the city attorney, and you and I. That was not an open meeting. That was not including everybody who is concerned about and would be impacted by this. And so I think this does give us
If you recall, you were supposed to, that was our second meeting, because the first meeting was much narrower with Mr. Butler, and I don't even remember who else was there. But we had agreed that we would each bring people in. So that's why I brought it, or Mr. Hyatt brought in the marina folks. It wasn't our fault that there weren't other people coming in from these groups.
There was no notice of this meeting. The community had no way of being aware of that.
Ross, you knew. I'm sorry.
I know that, but am I supposed to go out and go to all the representative groups and tell them, come Friday afternoon at 3
Well,
o'clock?
I misunderstood, because I thought you said that that's what you were going to do, that you would take care of that side of it, and I would speak to...
No, I said that side of it needs to be addressed.
Okay, well, there was a misunderstanding. So that committee, the expectation was that we would have a rounded discussion on both sides of the issues, and that didn't happen. And the next meeting, which we were supposed to have, which had better, the legislation more along the lines of what the mayor had proposed, didn't happen either. So here we are.
And you did mention joint meeting. I think that could be an efficient way to do it. I would be more than happy to meet jointly with environment and/or economic, or all three.
When's that Economic Matters meeting?
16.
16.
No, 11:20.
Oh, 11:20?
I thought it was the 16th.
It's apparently 20th.
The 20th? Okay.
Yeah, former days.
That was 10/16 was October.
So November 20th is the environmental or the economic matters.
Yes. Environmental Matters meets on the 14th.
And it's going to be at 5:30. It's usually at 6:30, but economics.
So
is
why
gonna be
don't we,
5:30.
because that gives us a little more time
Yeah.
to bring in people that we would like to hear from. And Kayla, or Ms. Jackson, I know we have issues with joint meetings, but we'll do it however you see fit. And if Environmental Matters wants to join that committee, or,
Alderman Savage is part of that committee.
Oh,
so,
okay, well-
already, so he's should be there.
It's pretty much between the four of us, we're on all of them.
We got
I
some
think
overlap.
Dewan gets in there too. but
Yes.
okay, I should just check, make sure I'm here.
You're on Environmental Matters with Rob and me.
Right, but you're not, I'm looking at the 20th to make sure I'm not.
Are you sure it's the 20th? Because I went to iLegislate and it said the 16th.
That's October 16th was the last.
Oh, all
Oh,
right.
we are in November,
November
Economic
20th,
Matters,
yes.
5:30.
So-
Got it.
November 1st. But
That's right, today's 20, I mean, it's the 20th, but you're
Well,
right.
we can have it on the
But,
20th and then have some Thanksgiving dinner.
but
Thanksgiving is the next week, right?
But Madam Chair, what I was about to say is I think one thing we do have some consensus on with this is that there's more work and meetings to do, but we have some folks who've been waiting a long time to give their testimony.
Yes, you're right, thank you. If you would like to come and speak to this, I know kept you waiting for 3 hours, and I apologize, but please feel free. You may come up to the table, or you may stand at the podium, whichever you're most comfortable with. Or you can tell us you don't want to do this and you'll wait until the 20th and do it between 3 committees. I'm just. No, I don't think so. It should be,
There we go.
there we go.
Good afternoon.
Afternoon.
I'm Bill Reichard. I'm with the Eastport Civic Association Board of Directors. And I'm going to be brief because, as you've noticed, both you and we have been here, a substantial amount of time this afternoon. I will tell you frankly that overhearing the conversation between the three of you this afternoon has been extremely revealing to me, and maybe to some of the others that are waiting here. The issue for us is very simple and direct, and that is we saw the task force resolution as a statement from our city government that you would take some formal step to take a very close look at an issue which you correctly identify has ramifications in the community, in the maritime community, for developers, for inclusiveness, in opportunity in our city, for all of the things that were mentioned within the last 20-minute conversation. In addition to that, we are learning, frankly, that there had been a number of discussions about this already at the level of city government, which we did not know about. That notwithstanding, it reemphasizes, as far as the community is concerned, that the effort going forward give the opportunity for notice, an opportunity for people to come and speak with you. Certainly the experts that we should be relying on, but also the people whose life in the community will be affected, or at least they believe it will be. I am really concerned when I hear words like, this issue has discriminatory aspects to it. I'm concerned when one of the concerns, frankly, of an alderman is that people come up to him and say they are being confronted, if you will, about a prospect that where they live is going to be described as a trailer park in the water or something of that nature, some derogatory connotation. If you're concerned about that, so are we. If you're concerned about discrimination in this issue, so are we. And so I'm suggesting that let's get it all on the table in a responsible and professional way. From the community's point of view, we are concerned that not only is this an enterprise, which is an opportunity and a potentially good business move on the part of developers, which is a legitimate process. But there also be some mechanism to evaluate community impact. I've worked on the Forest Drive Eastport Sector Study Task Force.
And thank you.
It took us 2 years. In fact, that's where I met Alderman Chandlemeyer. I sat next to you on that task force for the period of time that you served. And I remember we didn't agree on some things. But that was the first time that people sat down and really examined some of those issues. And there was tension. And it was remarkable that we had not only community members, but we had city, state, and county people sitting in the same room, in the same meetings, and I was told at some point that was the very first time that ever happened. Okay. Well, we don't need to take 2 years here, and I agree, and would promote the idea that this be done efficiently and expediently and so forth. But there is really no substitute for getting all the players in the same room with the same facts and get it out. If somebody thinks they're being discriminated against, get it out. Let's talk about it. If somebody thinks they're being railroaded into some derogatory or marginal living arrangement, let them speak. Let's hear from them. And I think if we do it right, and if we do it with notice, and we do it in an inclusive, cooperative fashion, we will succeed. That's what I have to tell you today. Thank you very much.
Thank you. And Mr. Reichert, I want to thank you because, and I'm taking great pride in that task force, but I selected every one of the 22 people on that task force based upon the professional knowledge that you brought. And it was extremely, I didn't remember that it took 2 years, but.
It's pandemic. We ran into the pandemic. But,
yes, so, but a phenomenal outcome. And such, as you said, we had everybody from every jurisdiction and every content area that impacted that decision. So I trust that we're going to do the same thing with this task force.
we can do it. We've done it, so we can do it.
That's right.
Thank you.
Thank you. Next.
My name is Evan Fallon. I live at 213 Lockwood Court.
I'm sorry, what's your name again?
My name is Evan Fallenberg. I live at 213 Lockwood Court. I'm an attorney, and I'd like to speak directly to the discriminatory assertion. Also the assertion that Mr. Marcellus Johnson made here the other night, that somehow the opposition was elitist. I'm an attorney, and I and my entire law firm spent 30 years solely representing housing issues for inner city children across the country, primarily though in Baltimore and DC. The other day I went on the Flow Homes website, and there were a lot of numbers tossed around here the other day, and I picked out a couple of nights next June, and for a one bedroom Flow Home houseboat, it was $891 a night. I think we can all agree that Annapolis is a more desirable location than Baltimore City. Otherwise, we wouldn't be living here. So I think it's perfectly foreseeable that a one-bedroom flow home rental here will be well in excess of $1,000 a night. So the idea that somehow the opposition to this is automatically elitist or discriminatory is patently insulting. The idea that somehow we're up here fighting this because we don't want inner city African Americans on our waters is patently ridiculous, and it's insulting. I spent my whole professional career fighting on behalf of the rights of inner city kids and their families. I think that the other thing I find, and I've heard this echoed throughout Eastport and my community, is the idea that this thing has come so far with apparently meetings with Mr. Johnson, meetings with Mr. Hyatt, the representative of the marinas, and now all of a sudden it's, on the verge of getting done, and we're just hearing about it in the community. I know a lot of people are very taken aback, and you heard it the other night about a lack of transparency. People are very concerned about it. Very few of the issues that I've heard that Ocean City addressed in terms of the health, safety, and welfare of their constituents, I haven't seen anything that addresses any of it. You're not allowed to build a boathouse on Spot Creek, but now all of a sudden, and you're not allowed to do that because of the adverse environmental impact. I haven't seen an environmental impact statement for any of this, but what people are proposing are houseboats, which are the same thing. They're with no requirement that they be moved, no enforcement mechanism, and Annapolis has a long, long history of a failure to enforce things that it lays down. I think if at $1,200 a night, I think unless there are very firm guardrails, I can't see any marina owner, especially Mr. Johnson, allowing anybody to be a liveaboard. Why would he? When he can make 10 to 15 times that amount of money on houseboats. The other thing that was very clear in the ordinance signed by Ocean City was that they were doing it to preserve the marine recreation environment of Ocean City. We have much more of an interest in that than Ocean City has. I mean, they have beaches and bars and all sorts of stuff. But I don't see houseboats as, for the same reason they didn't, I don't see houseboats as furthering those objectives. And I think without a task force, I know almost everybody I know is going to feel that there's been a real failure on the part of government to do their due diligence, and even a minimal amount of due diligence as far as good governance. And I think we'd be in danger of Annapolis turning from the sailing capital of the country to the houseboat capital of the country, and we would lose our identity. I'm not apologizing for being passionate because I feel like that's a very cheap shot, and I don't appreciate it. And I think to tar the opposition with that kind of brush is unfair and uncalled for. Thank you.
Mr. Evan, I'm sorry, I didn't get your last name. Who's Mr. Johnson? I didn't.
He means Mr.
Marcellus.
You're talking about Mr. Butler?
Mr. Butler, right.
Butler, I mean.
Oh, okay. I just want to clarify one thing.
Yes, please.
There are lots of issues that come before this body. All of it doesn't end up in legislation. We make every effort to meet with the community who have the concerns, and we meet with our department heads to try to resolve many, many, many issues. There was never an effort, and I too am passionate about almost everything that I speak on, so forgive me. But there was never an effort to keep anyone out of this discussion, okay? I called the original meeting to try to resolve what I heard from several people, including the mayor, as a concern. I had no clue it would escalate to this, but I also had no interest in leaving anyone's ideas or concerns out. My idea is always to get all the people in the room who are engaged in any form or fashion, hear them out, and come to some reasonable considerations, to come up with some options that everybody can live with. They may not love them all, they may not hate them all, but they can live with them, and that we as a city government can live with. So that's how we function. There is nothing divisive about what has happened in the past, and there was no deliberate attempt to try to keep anyone out. So I just want to be clear about that. So, but thank you for your concerns, and it's Mr. Butler.
Thank you. I meant Butler.
Madam Chair, Alderman Finlayson, and Alderman Arnett, Alderman Schindler. Thank you for the time. We had a very short notice to come here today. We appreciate the opportunity to be here. Some of what I'll say, I said on Monday at the City Council meeting, but I have some new things. I have in front of me.
Could you bring your mic a little bit closer? Are you hearing?
Oh, I'm sorry. Is that better?
Yes, sir. And can you please, for Ms. Jackson's purposes, give your name and address for our record?
Willard Sweetser, and I live at 5 Shipwright Harbor on Spa Creek in Annapolis. So to continue on, I have an ordinance from the Ocean City folks. It was first reading June 3rd, second reading June 17th, both of this year. And just the first thing here says, Ocean City finds that it's vital to the town for it to maintain its marinas and waterways for marine-related activities related to recreation, including but not limited to sport fishing and pleasure boating. Ocean City finds and determines that to promote and protect the public's health, safety, and welfare, a prohibition of the commercial operation of houseboats and the prohibition of the issuance of any license that would permit the commercial operation of houseboats is just and proper. That's the beginning of their banning houseboats completely. And as Evan Thalenberg just pointed out, Ocean City is bigger and more commercial-oriented than Annapolis. Annapolis has always been, to me, a sailboat and powerboating community. I've been to some places that had houseboats, and they're different. Why are they different? I don't know. They feel different. It's hard to express the feeling. But here we have an active group of racing sailors. Gary Jobson, the fellow who won the America's Cup with Ted Turner back in the 80s, he was here. He felt strongly enough about this to come here and talk about houseboats and the fact that there needs to be a committee to analyze what impact they will have on the community and what will happen to the feeling of Annapolis if this happens. Feelings are hard to quantify, but they're there, and they give people. I was just somebody just the other day who I said, I'm from Annapolis, and they said, I love Annapolis. I love the way it is. I like its boating community because I like boats. He wasn't talking about houseboats. He was talking about sailing boats and power boats. There's very little common thread and emotion and love for the people who are on houseboats and the people who are on power boats and sailing boats. It's different. It's hard to describe why they are different, but they're just different. So I'll go back towards yesterday and bring up a couple of things that folks mentioned that I thought a little more about. We're giving this a full creative group of people.
Sir, I apologize. Your mic is off. Yes, sir.
Push this.
Yes, sir. When the little green light.
I must have done it when I moved it. I'm sorry. But the people we're thinking about that I'm sure will end up on this committee, especially hearing Bill Reichert's testimony, it will be people who know what they're doing. They know about boats, they know about risks, they know about safety, they know about health and welfare of the people who are around them. The fire marshal's office has already said they do have concerns about houseboats. There are different things to look at with houseboats than there are in the other boats. There are more tendencies to have good, fun parties, which are all fine with me, but on a boat, they're a little different. The safety aspects are different than if it's at somebody's home or in a hotel room or whatever. In a place in a hotel might have a party after a meeting or whatever. So I think looking at what we're looking at for the next few meetings, we have the Maritime Advisory Board, the Port Wardens, the Environmental Matters Committee, this committee. We get down to the waste. The other day, Amy Clements spoke Monday evening at the City Council meeting. She is a president of a nonprofit called the Spa Creek Conservancy. It is very good at raising money to keep Spa Creek clean. There are tens of thousands of dollars that go through her, and I'm one of her contributors, that go through her company, her nonprofit 501c3, every year that does nothing but work on keeping the quality or improving the quality of the boat, of the water in Spa Creek, the water. That's her mission for running her company. Another type of boat, a houseboat, may have impacts on that water. If they're effluent, if they have something on all boats called gray water. What that really means is if you happen to have a sink on your boat and you wash dishes in the sink, that gray water is typically dismissed right into the water that the boat is in. There's no regulations for that like there is for sewage. But there'd be more water that's gray with houseboats because there's more dishes, more at home. So I'm going over most of the things that I talked in very short terms, but I say that I agree with the fellows who spoke before me, that this is an effort that needs to be very carefully, I guess you could call it, analyzed, verified, checked out. But I think we should do everything, as Alderperson Finlay said earlier. They should be a gold-plated staff of people. Thank you for the time to speak.
Thank you, sir, and for your second visit to us this week,
Yes.
isn't it?
I'm sorry, could you say that?
I said thank you for your second visit to us this
that's all
week.
right.
Mary O'Brien, 301 4th Street. Did that the last time I testified.
I apologize, Ms. O'Brien. For Ms. Jackson's purposes, could you please repeat your name and address a little more slowly for our records?
Yes, Mary O'Brien, 301 4th Street. And I apologize, I don't have had time for prepared remarks, but I just wanted to, and I don't want to sound like a broken record, but I just think that there is quite a lot of confusion, maybe in the community as well, maybe with non-boaters, even with boaters, over the term residential. Nobody is going to be residing on these businesses, and I think that the council would do well with divorcing the issue of personal pleasure craft with commercial uses. I think that might even help you guys get more to the heart of the issue here and be able to study it more effectively. I understand why perhaps when Mr. Butler testified, maybe his back is up on this subject. He's got beautiful boats, and maybe, feeling attacked on that issue. I don't think it matters the shape of the boat in terms as much in terms of that discussion as the purpose of the boat. I I mentioned in my testimony before, we have some lovely charters on my dock that are very popular. Everybody on the dock enjoys their presence there. Lovely sunset cruises, very sophisticated and nice as well. I think that if we were to study the issue of commercial vessels and maybe retitle this legislation, a task force to study commercial vessels, then we could compare them all together. Nice little small cruises, booze cruises, noise issues with those as well, with what is being proposed with Flow Home and some other business ventures. I don't think any of those things have anything to do with me, a 15-year resident of Annapolis, and folks that I know as well who have been in Eastport for upwards of 25 years, a gentleman who has spent most of his adult life aboard boats. We contribute to the culture of the maritime zone and the community. We are also old Eastport. Maybe not me with just my 15 years. I'm the junior one on my dock, even if you can believe that, with just 15 years aboard. So I think a lot of the people I speak to, we're an integral part and fabric of that community, and we aren't businesses, we aren't business owners, but I do support the businesses, the charters and short-term rentals and things like that are happening related to maritime vessels, if they're done within reason and kind of small and to fit into with the small historic character of our neighborhood. I don't support 80 house barges suddenly being put in all around Annapolis, or houseboats, or whatever you might want to call them, or whatnot. I would think that would be kind of silly to suddenly have a ton of short-term rentals happening. But on a small scale, I think that could be worked out through some sort of task force or other discussions, or however it shakes out, with getting the residents' opinions and voices into that process. But I just do think that this could easily first be divorced completely by having a task force on commercial vessels. And I think that even the aims of the people, Mr. Butler and others, would be better served if they were having a fair comparison against other charters who, like I said, are quite sophisticated and beautiful as well, and not be feeling the need to be fighting against our barges or our boats are just the same as Fleming's and blah, blah, blah and stuff, as that was expressed before. I don't think that that's even the issue. I think we should be comparing charters to charters, apples to apples here. I think that would help everybody. Thanks.
Thank you. And thank you for coming the second time this week, too.
And did you think you were going to have this much fun on a Friday afternoon?
Of course, Ross is sponsoring drinks afterwards, so he'll just tell you where later.
Let's all go to AYC.
So, all right. I don't see anyone else speaking. Would you gentlemen like to make an amendment or make a motion to postpone action on R4624?
I'll make that motion, Madam Chair.
I'll second that motion.
Okay, we have, I think, asked Ms. Jackson to see if she can pull together a joint committee, at least with Economic Matters, and anybody else that wants to join, and that we put out a notice as far and broad as we can to everybody or anybody who's got information to share. I would like to warn us, I'd like to create 2 columns for that information. One is more anecdotal and one is more data-driven.
Right.
So I'm not sure how we do that in the meeting or how we do that in our announcements, but I think that's going to be important. Or if not, we're going to have more than we might be able to handle. I'll just put it that way. So I'll entertain your ideas on how we can do that.
I would like to add environmental matters, since it's you and I and
And we'll
Rob.
already be here, in other words, right?
Right.
So environmental matters
Environmental and economic.
and economic, and then, of course, so, yeah.
Those were all 3 examples.
So the only other person missing is Rob.
And
Rob's on
Dewan.
Economic Matters.
Rob's on economic matters. And we're on environmental matters with Rob.
Yes.
Isn't Dewan in there?
Dewan's on economic,
On economic.
Oh,
Dawn's on economic.
he's on economics. So we'll have 5 of us here.
We really ought to have council work sessions where we can have public participation. I mean, this is ideal for inviting all council members who could attend, all public who would like to listen but also maybe speak. And the way our work sessions are constructed now, they're just so constraining.
Well, let me ask Ms. Buckland, is there a chance we could have a work session this month that would allow the 3 committees and others to come and really conduct? We couldn't conduct business if we do it in a work session unless it precedes the joint committee, in which case we could hear testimony during the work session and then we could formulate our opinions by committee. I don't know how to best make that work.
I am not aware of any constraints on your ability to request such a thing. I'm looking at Kaylin as I say that. I believe you have the ability to ask for.
We do encourage the public to come to the work sessions.
We what?
We do encourage
Yeah,
we encourage the public to come to the work sessions. They just do not
they
come
can't
to the
But
work sessions.
they can't speak during a work session.
I'm sure that we can.
Well, so this one will be unique in that respect. We're
Right.
looking for testimony. I would just like for us to delineate public data-driven testimony versus more personal experience. Anecdotal legislation, just so we can handle it, because, you know.
If we have a work session, Rob and I are Waterside older persons, Karma and Harry are also, but they're not in any of those committees. So it just seems to me, I don't think the council has the opportunity to sit down and talk to each other enough on any issue. But having one where we're talking and making the sausage, but where the community can also be heard. Now, that'll be a long meeting. But
Well, yeah.
I think everybody is saying
Early.
the transparency and involvement is worth doing.
So maybe we try to start a work session at 1 o'clock, and we say for the first hour, we'll take anecdotal we'll take, first 2 hours, we'll take data-driven testimonies. And then for the next 2 hours, we take anecdotal testimony, or something like that.
Yeah, I believe you have I'm not aware of any constraints on your ability to do that.
I think the first issue is whether we can get a date for a work session.
Okay.
And then to make sure that all of our colleagues understand the significance of this work session. And the change of the format, the fact that we'll take public testimony, and at which time we can ask questions and get clarification from any and everybody, because traditionally we don't do that in a work session either.
I'm free on the 28th,
I am not. That is the holiday, is it not?
Thanksgiving.
I know it is. I already checked, because the 20th is the week before. So Ms. Buckland, if you could look into that for us and see when we can meet, and we have a tentative date for the 20th for the joint committee, so we'd like to have it before the joint committee can make the 3 committees can make their recommendations. And in the meantime, we're all free to look at the legislation, see if we can come up with some amendments that will help us move it forward. Because the idea is to get it out as soon as possible so that the timeline that's given is a reasonable one.
Makes sense.
So, okay, so we have a motion postponed, do we not?
Yes.
Or has that been made?
It's been made and seconded.
Okay, further discussion? All right, all in favor, please say aye.
Aye.
Aye. Okay, thank you very much. Thank you, sir and miss, for coming and staying. and your testimony. All right, and that exhausts the operative word.
Indeed.
Our agenda for today. Anything else for the good of the order? All right, I'll entertain a motion to adjourn.
So moved.
Second?
All in favor?
Aye.
Aye.
I have another meeting now.
First, Panda, do.
Who is that?